And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for this plea?
No, sir.
You understand by entering a plea to the possession of controlled substance and paraphernalia that there won't be a trial of any kind.
Yes, sir.
And you understand that you're giving up your trial rights, which are on page 1 of the document that you signed.
Yes, sir.
You understand that you're waiving all potential defenses that you may have.
Yes, sir.
And do you understand that it's a withhold of adjudication, so it's not a conviction? You understand that part?
Yes, sir.
All right, I didn't previously announce that. And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and what is your plea to the counts of possession of a controlled substance, lesser included of count 3, and possession of drug paraphernalia?
No contest.
All right, I'm going to accept your no contest plea to those 2 counts. It's freely, voluntarily, and knowingly given. Does the state have an announcement on 1, 2, 4, 5, 6, and 8?
Yes, Your Honor, we're going to null pros those.
Those counts have all been null pros or dismissed by the state. As far as your sentence, Mr. Sapp, as agreed upon with the state, it's time served on count 7. On count 3, it's 6 months of community control, followed by 2.5 years or 30 months of standard probation. Court costs of $515, is that right? Okay. And substance abuse evaluation to be done within 30 days, treatment to start within 60. And cost of supervision would be $40 per month. Okay, I'm just going to write that in there if y'all don't mind. All right, again, so withhold adjudication on both counts. So, Mr. Sapp, I'm going to need you to talk to probation, who's at the table right next to you, behind you there. And you have 30 days to appeal the judgment and sentence of this court. This is a guideline sentence pursuant to the guidelines I have, and we're given it's 20.7 points, so it's a guideline sentence. All right. Anything else from Mr. Sapp?
That's everything, Your
All
Honor.
right, go talk to
Thank you, Your Honor.
probation. Thank you, Mr. Sapp.
I think that's all I have, if I may be excused.
Yes, sir.
Thank you very much.
Thank you. Ms. Merrifield? Morning. I'll skip number 3 on the list. It's just blank.
Give myself a buffer. I don't think it
Oh,
worked,
sorry.
but we're good to go. Good morning, Judge. My cases are under Flaherty. The first case I have is Joe Arab Fernandez in 24 CF 2667. He is present, and we have reached an agreement, if I may approach.
Yes, ma'am. Thank you.
And he is withdrawing his previously entered not guilty plea, entering a no contest plea. As shown in the agreement, count 1 would be dismissed, and the plea would be to counts 2 and 3 as a legitimate uncoerced plea bargain, Judge.
All right, there's talking here, Ms. Merrifield, of a transfer of probation.
So I put that in there just, really just to provide a safeguard. Mr. Fernandez does have a stable residence here in Okaloosa County, intends to remain in Okaloosa County until the event that a transfer can take place. It's not a necessity, but he is a resident of another state and would like the opportunity to transfer if possible. He understands that that really would be based on that, that home state willing to accept him.
Okay, and what state is that?
California, and in the alternative, he would remain in Florida and has made arrangements to do so. So I don't anticipate that we'll initiate a probation transfer today, but giving him the opportunity in the future so that he understands exactly what takes place in order to do so.
Mr. Fernandez, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name, please?
Your full name.
It's Joy Fernandez,
All right, and your date of birth?
February 15, 1989.
Mr. Fernandez, you're here in 24 CF 2667, where I've been given, it's listed as a sentencing recommendation, but it's really a plea and sentencing agreement between you and the state that would have them dismissing count 1. On count 2, which is traveling to meet a minor, is 120 months or 10 years of sex offender probation, $40 per month cost of supervision, $669 court costs, sex offender evaluation and counseling, no unsupervised contact with any minors, not being any place that minors congregate, no electronic devices capable of internet until after the completion of a risk assessment as allowed by statute, contact with familial minors. I'm not sure if we've got a definition of familial.
Any minors that are related to immediate family.
Okay.
It's our understanding that that is not allowed until after the risk assessment or after the counseling and completion of a risk assessment. Again, in abundance of caution, I wanted to make sure that was memorialized in writing.
All right, so contact with familiar minors may be permitted after completion of that risk assessment as allowed by probation and pursuant to Florida statute. GPS monitor pursuant to the Jessica Lunsford Act at $1 per day. It says probation to automatically terminate at 60 months if all conditions are complete and no violations have occurred. Count 3 is 60-month sex offender probation concurrent with count 2. And then, as discussed, probation may transfer upon proof of residency and applicable transfer fees, but you'll understand you'll stay in Florida until that's been approved by the Department of Corrections in the state of California. Agrees to supervise you there. Do you understand all that? Is that the agreement that you've made with the state?
Yes.
Is this the state's agreement?
It is the state's agreement, Your Honor. Additionally, I do want to be clear that Mr. Fernandez does understand, even though the probation will terminate at either the 5 or 10-year point, the sex offender registration will be for life. And he must do so in California as well.
Okay, so do you understand that, Mr. Fernandez, that even once your probation is terminated, you'd still have to register as a sexual offender for the remainder of your life?
Yes, Your Honor.
Okay. All right, is this what you want to do today?
Yes, Your Honor.
All right, have you gone over this plea and sentencing agreement with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it?
Yes, Your Honor.
Are you satisfied with your attorney's advice and representation?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No, Your Honor.
You understand by entering this plea there won't be a trial of any kind?
Yes, Your Honor.
You understand that it'll be adjudicated guilty of these offenses, which means they're felony convictions?
Yes, Your Honor.
You understand that you're giving up all of your trial rights, which are on page 2 of the agreement that you signed?
Yes, Your Honor.
And do you understand that you're waiving all potential defenses that you may have?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, Your Honor.
Looking at the sentencing guidelines, which show the lowest permissible prison sentence of 23.7 points. What's the reason for the downward departure?
It's a legitimate uncoerced plea, Your Honor.
Okay. So do you You understand that, Mr. Fernandez, that the only reason that this wouldn't lead to you going to prison is because the state agreed to a downward departure?
Yes, Your Honor.
And what is your plea to count 2, traveling to meet a minor to engage in sexual contact, and 3, unlawful use of a two-way communication device?
No contest, Your Honor.
And does the state have an announcement as to count 1?
As to count 1, Your Honor, the state would announce an all process in return for the plea to count 2 and 3.
States dismiss count 1 based on your pleas to 2 and 3. All right, I'll accept your no contest plea as freely, voluntarily, knowingly given as to counts 2 and 3, adjudicate you guilty, 120 months or 10 years of sex offender probation, $40 per month cost of supervision. If you ultimately transfer back to California where you're from, they may have a different cost, so you'll have to inquire into that at some point. $669 in court costs, sex offender evaluation and counseling, no unsupervised contact with any minors, not be in a place minors congregate. You're not to have any electronic devices capable of internet until after the completion of a risk assessment as allowed by statute. So that means including a cell phone. If it can touch the internet, you can't have it. Contact with familial minors may be permitted after completion of a risk assessment as allowed by probation, GPS monitor, $1 per day, probation to automatically terminate at 6 months or 60 months or 5 years if all conditions are complete and no violations have occurred. Count 3 is 60 months of sex offender probation concurrent with count 2. The court doesn't have any objection to the defendant transferring his probation and residence to California if that's approved through the interstate compact, but you'll have to remain present here in Florida until that's approved. Anything that I've missed?
Nothing.
Okay. And as previously stated, this is a downward departure based on an uncoerced plea bargain with the state. Fernandez, you're going to have to talk to probation, or do you want fingerprints first? You have to be fingerprinted, then afterwards talk to probation so they can instruct you, and then you're going to have 30 days to appeal the judgment and sentence of this court. I'm looking at you.
That's okay.
Ms. Merrick.
The next case I have is Mary Lee Perrin, 24 CF 2190. Ms. Perrin is present and approaching. And Judge, we have reached an agreement to PTI, if I may approach.
It's a plea to PTI?
It is, Judge. So I've got the score sheet behind.
All right, thank you.
And we do have executed pretrial intervention agreement that she'll take with her to the probation office once we complete today. Ms. Perrin is withdrawing her previously entered not guilty and entering a no contest to the diversion as articulated in the agreement.
Okay, you all have the agreement there, so probation here in the courtroom can see it?
Yes.
Okay, you've got it already?
We do.
Well, you've got the pleas. Is there,
They have a copy of page 1 to help them, but we also have the signed agreement.
okay, what I was looking at looked like the plea agreement from what that you're holding up. I just want to make sure they had everything. All right, Ms. Perrin, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Mary Lee Fay Pear, 7/16 of 1985.
Okay. Is Pear your last name, or is it Fay Pear? I just make sure I'm getting it.
Pear.
It's just Pear, okay.
Yes, sir.
All right, Ms. Pear, you're here in 24 CF 2190. You're charged with grand theft over $10,000, but less than $20,000, which is a third-degree felony, where you are looking at a maximum of 5 years Department of Corrections. Do you understand that?
Yes, sir.
All right. I've been handing a sentencing recommendation or plea and sentencing agreement that calls for you to plead to the court with a deferred sentence to complete a pretrial intervention. If you successfully complete that pretrial intervention, then you may withdraw your plea and the case would be dismissed at that time. If you do not successfully complete the PTI or pretrial intervention, you come back to this court directly for sentencing, where you could receive up to the 5 years of state prison. Do you understand that?
Yes, sir.
Not to say that I would give that or not give that, it's just make sure you understand what the maximum is.
Yes, sir.
I've been Given the agreement that shows a term of pretrial intervention that says 48 months or 4 years of term for the pretrial intervention, $40 per month cost of supervision, 518 court costs, restitution in the amount of $17,929.13 to the Public Consulting Group, Department of Financial Services, payable in minimum monthly payments of, is it 385?
385, Judge. That would complete it within 47.
Done by that time.
Yes.
I just want to make sure, because it looks like it was whited out and a new number was written in. I just want to make sure everyone's clear on that number. All right. $385 per month, execute the DCF disqualification consent agreement, and show proof of an anti-theft course. Are those the terms that you understood, Ms. Perry?
Yes, sir.
All right. And is that what
We
you,
would just request, I'm sorry to interrupt, we
Go
would
ahead.
request waiving the cost of supervision in light of the significant restitution, so that those payments are still, Ms. Perry can make those payments, and also so the court is aware, we did both confirm with the intervention program, with probation, that the 48-month term is allowable. I know that's a little longer than most.
I'm not sure I've seen it that long,
Yes, sir.
as far as a PTI agreement before. Any objection from the state or probation regarding the cost of supervision?
No objection from the state.
I'll waive cost of supervision as part of the sentencing recommendation in PTI.
Thank you, Judge.
All right, Ms. Perry, is that what you want to do today?
Yes, sir.
Have you already gone over this agreement and the PTI agreement with your lawyer?
Yes, sir.
And did you understand the agreement?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with the advice and representation from your lawyer?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this agreement?
No, sir.
Has anyone promised you anything in return for your agreement?
No, sir.
Do you understand that by entering into this agreement, you're giving up your right to a trial?
Yes, sir.
And you're giving up your trial rights, which are on page 2 of the document that you signed.
Yes, sir.
Do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that entering into this agreement, if you're not a U.S. citizen, could lead to your deportation?
Yes, sir.
All right, and what is your plea to the grand theft charge?
No contest.
It's a withhold of adjudication, obviously, while that's pending, correct?
Yes, sir.
All right. I'll accept your no contest plea is freely, voluntarily, knowingly given, withhold adjudication, defer sentence until the defendant either completes or doesn't complete the pretrial intervention agreement. If, Ms. Perry, if you successfully complete the PTI, you can withdraw your plea and the case would be dismissed. If you don't successfully complete that PTI, you'll just come back directly for sentencing, which again can be up to 5 years in state prison or 5 years state probation, 48 months for the pretrial intervention agreement, waive cost of supervision as discussed, 518 court cost restitution, the amount of $17,929.13 to Public Consulting Group, Department of Financial Services, payable in minimum monthly payments of $385 per month. Execute the DCF, or Department of Children and Families disqualification consent agreement, and show proof of an anti-theft course. Do you understand all those terms?
Yes, sir.
All right. Yes, ma'am. I understand. So technically, it's not a withhold or an adjudication of guilt. That would be determined at sentencing if you were to come back on a violation of the agreement. Do you understand that, Ms. Perry?
Yes, sir.
All right. Anything else that I may have missed?
Nothing from the defense.
Okay, and I show that the guideline sentence was, because of 22 points, there was no guideline, lowest permissible sentence. I'm going to have you go over and speak with probation. Then you have 30 days to appeal the judgment and sentence of this court. Although, again, this is pretrial intervention. If you do everything you're supposed to, the case will be dismissed.
Thank you, Judge. That's all I have this morning.
Okay. I don't think we do that, but because since the paperwork's being delivered at this point, do you mean as far as delivered to the clerk's office and that reason, we'll put it on August 25th to be removed once the paperwork is processed.
Thank you, Judge.
Was that all you had, Ms.?
That's all I have, Judge.
I keep looking at it where it says Flaherty next to your name. I want to tell you that for some reason. I don't know why.
Good morning, Your Honor. Joseph Riossi for David Paul Bradley, 2025 CF 1841C. Your Honor, I had set this for trial, but I had spoke with Mr. Bradley last, over the weekend, and he's under the impression that the witness is not, the victim's not available, but she is, and
What
he had-
witness? One of his witnesses or a state's witness?
The state's witness, Von Seal Trawick, is available to testify. At the last hearing, you asked the defendant whether he knew and understood what he was facing, and he said at the end there, he wasn't aware that he was facing up to 15 years. And then he asked me to, he said, well, why don't you just get the phone calls that me and Ms. Trawick had? And I said, well, we hadn't discussed any phone calls. So with him bringing up new evidence that he wants presented at trial, and the availability of Mr. Trawick and his expectations that he doesn't, so I'd ask that the court allow me to continue this case one cycle to depose Ms. Trawick and secure phone conversations between him and Ms. Trawick that were recorded at the jail.
There is no objection, Your Honor.
Do y'all have the phone recordings that he's
I don't have-
asking about?
He just mentioned them to me. I'm not aware of those.
Okay,
But he can make a request to the jail
okay.
to get them.
I just want to make sure if y'all had them, just if they're going to get turned over, he has to go seek them out.
No,
So
no,
when we're here
no.
next time, I just know how the process had to work.
Yes, sir. I don't know.
And Mr. Riossi, I can see you were just appointed a couple of months ago, so I know you're catching up to the speed with the case, even though it's pushing a year old.
It's I have to make sure that he understands thoroughly that he could be facing up to 15 years in prison, and it's the facts are kind of egregious. So if Ms. Trawick appears and testifies at trial, and the jury takes that testimony, then the outcome will be significantly different than he's expecting.
One thing I would like to mention, Your Honor, if I may.
Go ahead.
He's mentioning phone calls with the victim. I'm not sure he's aware there is a no contact with the victim in place. So he's not allowed to have those contacts. He's just,
And I explained to him, I didn't know whether or not phone conversations between him and the victim might result in him state reviewing.
Let me make sure I just understand what you announced, Mr. Riossi, is that your client wants to continue the case in order to get recordings of conversations between him and the alleged victim while there was a no contact in place. Just to make sure that you're aware, Mr. Bradley, I'm looking at your paperwork from first appearance, where the first appearance judge ordered that you have no contact with Ms. Trawick. So certainly going forward, make sure that you abide by that order of the court.
Yes, sir.
and obviously the state is going to now investigate because that's a crime for itself. Violation of pretrial release is a misdemeanor.
And that's, sometimes I go out of my way to make sure that, especially when I cover first appearances on a weekend or a holiday, is that no contact with the victim or any other types of terms like that at first appearances are not just if you bond out. They're the conditions that the court's placing on you from that day forward, regardless if you bond out. So I try to make a big point of that. I'm not sure how that may have been explained to you, Mr. Bradley, but That's typically how it works.
Your Honor, I filed for a motion for bond, to address his bond, and that's already a record, and I'll negotiate with your JA as to set that.
Is that the purpose of it, is to allow for contact? When was the motion filed, Mr. Rios?
It was filed about six days ago.
Okay, so that's not appearing in the court docket yet due to the
Yes.
processing concerns that we've been talking about for a couple of weeks now.
Yeah.
But just make sure that if that gets set for hearing, if you don't see it on the docket, I can't see it at all, so make sure you send me a copy of it so I can read it in advance.
Yes, Your Honor. We just addressed that already.
Anything else we want to address for Mr. Bradley?
No, Your Honor.
August 27th at 9 o'clock will be your next court date, Mr. Bradley. Obviously, if your attorney sets up another motion hearing before then, we'll address it, but all terms previously entered by the court as far as your first appearance conditions are still in place. So make sure you, if you've got a question about that, talk to Mr. Riosty about it. All right, thank you, Mr. Bradley.
We might approach on Mr. Douglas, Your Honor.
Give me just a second.
Here in Crestview, we have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa. Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, what are you requesting, Mr. Riasti?
Joseph Riasti for Christian Alexander Douglas, 2023 CF 111. I'm asking that the case continue, the court continue this case one last time. My client is asking me to demand speedy trial, and I've explained the issues with him with regarding to the cell phone. So based upon that we haven't procured the cell phone, the needed cell phone information as of this point, I'd ask that the court allow us one more continuance in order to procure the cell phone data.
State?
The state does not object.
Okay. It's my understanding there was a technical issue with the downloads, and they may have to either be redone or there's just things missing, and the person who can do that is currently out of pocket.
Yes, Your Honor.
Correct?
Yes, Your Honor.
The other thing I stated is any motions that are regarding these phones or search warrants for these phones needs to be done as quickly as possible. And we've discussed some of these issues since our December 30th pretrial, which was my first pretrial in this case.
Yes.
I mean, I haven't gone back before that. I probably did back in December. I went back and looked what happened before I got here, but I don't recall it off the top of my head at this point. But I know we've talked about this at least 5 or 6 times, these issues. And this is why I try to impress upon people that issues like these need to be dealt with as quickly as possible, because there's almost invariably is probably not a great term of art, but often there are situations where there are technical difficulties, things can't get processed quickly, schedules can't be coordinated to look at the evidence at the same time, and it leads to these repeated continuances on things that could have been handled much earlier. Mr. Douglas, I can't tell you anything else about speedy trial other than talk to your lawyer about what you can file at this point as far as a speedy trial. Any motion regarding a motion to compel or concerns with what's on these phones or what has or has not been turned over, they just need to get filed and set for hearing. I hear probably half the information that y'all have, and I try to steer a course for the case to get it resolved, but I certainly don't know everything because I only know what I'm being told. But I've certainly would like to have this issue come to a resolution so we can set your case for trial, Mr. Douglas. Speedy trial in a case that's, I think 2.5 years old.
Well, it's from 2022, the incident.
So, obviously there's been numerous continuances in the case, but there's a way to kind of reinstitute the speedy trial issue, but it just involves, filing some paperwork with the court if that's what you want. I guess this one's for everybody too, and just a little reminder that the Supreme Court has changed the speedy trial rule effective July 1st, which is tomorrow. Now, I don't think that necessarily covers cases that were in existence at the time, but y'all might want to take a look at it as just kind of a heads up that speedy trial has changed somewhat drastically starting tomorrow. I was at a conference over the weekend and not only heard Supreme Court justices speak about it, but talked to them about it as well. So I think it's important y'all take a look.
Yes, Your Honor.
Mr. Douglas, anything else that you want to bring up?
Resolve the case as soon as possible, Your Honor. Process of losing custody of my children. Incarcerated on this charge that I'm innocent on. Big run around game with getting information off the phones. My attorney told me the state couldn't get the information. She took the phones to her private residence to get the information. Showed me text messages of it, pictures of it. I think that's
Wait, I'm not sure what you're saying.
It was just the transfer of the data from one memory device to the memory device that they were giving me.
Okay, so what you're talking about is like a thumb drive that has the phone contents was taken to a personal home.
Well, no, Your Honor, let me explain.
Not the phones.
No, Your Honor, this just, okay. I was showing Mr. Riosti the efforts that I personally put into transferring the data from the flash drive to his hard drive, because our internet capabilities in the office are very, very bad. I took that to my home and used my own internet service to expedite the process, and I was showing...
Of moving it from one storage device to another?
Yes, Your Honor.
Okay, so it's not really a chain of custody issue.
No.
I just want to make sure of that.
Right, I know.
Because it's basically making a copy of a copy, but the original is still in lockdown custody of the sheriff's office.
That is correct.
Okay.
Yes.
That makes me feel a little bit better.
I know.
Any other questions or concerns about that, Mr. Douglas?
move forward and prevail in this case and resolve it. Like I said, my children, they need their father. I've been incarcerated approximately 38 months on this charge.
All right. Well, obviously, I've been pushing on it as much as I can, Mr. Douglas, without anything else being filed. If you have any concerns, you can certainly file your own. But just know I can only deal with things as they're brought to my attention. I don't have the ability to there's a Latin term that we use, sua sponte, which means doing things on my own, is very limited. But I think I've expressed the court's concerns numerous times about this case and how it needs to be resolved, because without this phone information that, again, hasn't been really sought by seemingly anyone for at least 30 months, I can't go back in time and change those things, Mr. Douglas, but I've certainly tried to push it as much as I can since I've taken it over. All right. Any other concerns?
Motion eliminating evidentiary hearing.
Well, I expect those things will be done. I think part of the issue is until he has all of the information and the phone downloads, you don't know what it is yet. But that needs to be done now. I've expressed that to both the lawyers and in front of you numerous times now, Mr. Douglas, either at the bench or without them up at the bench. But this has been going on for 6 months, and I think I've been as patient as I can be at this point, but it needs to be resolved. So, Mr. Douglas, your next court date, pretrial-wise, is going to be August 27th at 9 o'clock. If there's going to be any motions, they need to be set before then. I'll certainly even consider special setting on different dates if need be for this case, because it needs to be resolved. And if there's going to be lengthy hearings, I want to make sure we have all the time we need for it. Anything else?
No, Your Honor, not from the state.
That's all I have before, Your Honor.
All right, August 27th, 9 o'clock. Thank you, Mr. Douglas. Mr. Hardy.
Good morning, Your Honor. Ryan Hardy with Caleb Thompson. And Your Honor, if you remember, we were here previously on a motion to modify Mr. Thompson's pretrial release. The court wanted to hear from some of the services Mr. Thompson's working with. Your Honor, we have both Embrace.
Oh, is this the Embrace issue?
Yes, we have both Embrace and in-home services here today, Your Honor. Ms. Tierica Sherrod from Embrace and Erica Allen from In-Home Services. Ask them to come forward.
All right, are they present?
Yes, Your Honor.
All right, you can go to this podium here. What would you like to present from?
Your Honor, this is Ms. Tierica Sherrod from Embrace, and I'll just ask her a few questions.
Okay, go ahead.
Ms. Sherrod, are you working with Mr. Caleb Thompson?
Yes, I am.
And through the process, have you met with him?
Yes,
And he participated in everything you've asked him to do?
every last meeting.
And what is Embrace doing with Mr. Thompson?
The goals that were identified is he wanted to do some emotion regulation and parenting with emphasis on communication and discipline.
And have you seen any issues or concerns from Mr. Thompson?
No,
Have you seen anything that would give you cause to think he shouldn't be allowed to be around his own children?
no,
Have you given any cause to believe he shouldn't be around any children?
no.
There was a DCF case. Has that been closed?
Yes, it has been closed.
And is Mr. Thompson freely and voluntarily participating with Embrace?
Yes, and Embrace, all of my clients have to be willing and able to work with me.
And do you believe that Mr. Thompson, his pretrial release should be changed to allow him contact with children?
My professional belief, yes, so that I can observe his interaction.
Thank you.
All right, a couple of questions for you. I'm sorry.
Okay.
Can you explain to me kind of what Embrace's role is through DCF or FFN in these cases?
DCF and FFN, they actually send us our referrals when they identify that there's a safety risk in the house or any kind of incident has happened. Instead of trying to remove children from the household. They put in-home services to work on any kind of identified safety measures. So being that this was an allegation of corporal punishment, we're doing communication and parenting.
And how long has Mr. Thompson been doing this?
It's a 90-day program, and I see my clients twice a week.
How far into the program is he?
We began on the 6th of June.
So it's only been 3 weeks or so.
Almost a month.
On the 6th of June, Mr. Hardy, your motion was filed in May.
Yes, Your Honor. At that point, Mr. Thompson was working with Embrace in Home Services and DCF at that point.
Can I say something?
Please.
We usually have a long waiting list, and whenever my clients close, that's whenever I can get a new case. So he was on the wait list until I became free. I just wanted to point that out. It's nothing dealing with his availability. We can only work with up to 6 families apiece.
You can be seated, thank you. Oh, I'm sorry, for your full name, please.
What?
Your name, please.
Oh, Terica Sherrod, Terika. Sherrod is Sherrod. And I'm a family intervention specialist.
Thank you. Has the state discussed this issue with the mother? I think it's a step family situation too as well, I think.
We spoke to her prior to the first court hearing, which is why we were opposed to it based on the nature of the allegations and her input. She did feel that there was a concern, that there's a danger, and we have not spoken to her since to see if that has changed. I know that we had concerns at the time on the 3rd when we were here that the defendant had not contacted the in-home services until the day before we came to court. So he had not been participating, but no, we have not gotten any updates from her.
All right, has anyone else seen this letter that's filed in the court file?
I have, Your Honor.
Basso, have you seen the letter that was filed on May 30th?
I may have seen it, but it's been a minute.
Are you aware, are there any family court cases pending with Mr. Thompson?
There are not, Your Honor. Well, there was a motion for contempt filed, but that's it. I represent him in that case as well, Your Honor. But there's nothing restricting his access outside of this case. There was an injunction filed that was dismissed.
That's what I'm trying to look through
Yes.
as well. So injunctions were filed in the family division, and it looks like they were dismissed. Both.
Correct.
Your Honor, just briefly to answer the court's question, yes, I had seen that letter. Looking at it again, it did refresh my recollection.
Okay.
And Your Honor, I said contempt. I meant a supplemental petition to modify in the family law case.
That was the paternity case from
Yes, Your Honor.
2020?
Yes, 2020 DR 621.
All right, that was filed in May as well.
Yes.
Ma'am, and do you have any questions for her?
State your name, please.
Erica Allen,
And where do you work at, Ms. Allen?
Emerald Coast Children's Advocacy Center for the In-Home Support Services Program.
And you've had a chance to work with and meet with Mr. Caleb Thompson?
Yes, I work with him and his wife.
And he's participating in doing everything that's been asked of him?
Yes, he has.
And do you see any issues or concerns with Mr. Thompson being able to see his children?
No, sir, I do not.
I don't have any other questions.
Thank you, ma'am. Did you get do you need a spelling, Eric?
I can give it to you if you need.
No, it's fine. I just want to make sure everyone's got what they need. My concerns right now are, again, every defendant is innocent until proven guilty, but the allegations that I've read in this case are significant. What I'm concerned about is contact with at least the child who was involved in this and doing that in a proper therapeutic environment because of the concerns that, and I bring this up because I know, I'm sure Mr. Hardy, you're aware, I was in the dependency division and family law division for 3.5 years, since the 3.5 years I was before I got over here in this criminal division. And I've had cases where I think the criminal court has severely affected how DCF cases, dependency cases. I'm looking kind of randomly out into the audience right now, and there's a lawyer here who was a part of one of those cases where when I took it over in another county, the parents had not seen their child for 18 months because of what the criminal court said, but they couldn't serve their do any of the treatment and counseling and things like that in the dependency court because of what criminal court had done. So I say that to make sure you understand where I'm coming from, and that I want to make sure that what can be done will be done, but it has to be at the proper pace. So based on that, and until I get a chance to hear from potentially the mother of these children, I think there's maybe more or something, at least an affidavit from them, I'd be potentially willing to consider, is to do any supervision or any visitation to be done supervised at this point. Otherwise, I think we're put in a situation where things may progress too quickly and cause more problems.
Your Honor, if we went to family court and got an order, supervised visitation, therapy, would this court be inclined to allow that?
I think I would be inclined. I can't say I would do it for guaranteed, because I just would like to know kind of how it went down and see what it is. But again, family courts are better suited to handle these types of issues, or a dependency court. But obviously, there's no DCF case at this point. But family court usually can spend the time and going into these different types of issue than criminal court can, certainly in the time that we have really to spend on these issues. So if that were to happen, I would certainly consider that. So if you're going to file anything further, Mr. Hardy, just attach whatever order comes from the family law court, and I'll certainly consider that when we come back for a hearing. But until now, what I would say is no violent contact, but it must be supervised with the children. And for the child who's the alleged victim in the case, I would say therapeutic supervision. If the child's in counseling, I'm not sure of that at this point, Mr. Hardy, but I think that would be the proper thing for the child at this point.
Yes, Your Honor.
All right. All right, thank you, Mr. Thompson.
Your Honor, outside of his own children, we also asked for him to be allowed to have contact with minors in general. Does the court have an issue with that?
Well, again, this is a corporal punishment case, right? So my concern would be any, I mean, if it's one thing to be in a public place with a child who's not his own, but it's another to be behind closed doors, where, future things like this could happen. So if it's a stepchild, if something's going to come from the parents of those children, because obviously there's, I guess, his wife is the mother that you're talking about.
Your Honor, what I'm talking about is if he's got kids who play football, for instance, if he goes to football practice and he's around kids, is he going to be allowed to do that? Can we?
State have any position on that?
Your Honor, as long as it's supervised.
What I would say is, it doesn't necessarily have to be supervised, but I don't want him to be in a situation where he's of a supervisory or parental role over another child without the consent of the parents. As far as being alone with other children, that would be a concern. Being at the same place where children are, for example, being at a kid's football game, a youth football game, and there's other children there, but he's not having some sort of supervisory role or contact with them, then that I'm okay with that. But otherwise, until we get through this process, I think that's the way to stay. And if Mr. Hart, if you could just, I know that the clerk takes great minutes on these things, but I think to spell it out in a specific order, that way if there are any concerns, it's a little more clear cut, that it's spelled out over paragraphs instead of, boxes that get checked and things like that. So if you send that to me in a Word format, I'll take a look at it and brush it up any way I think that needs to be.
Thank you, Your Honor.
All right, thank you. What are we doing as far as this case?
If we could just set this on the next pretrial.
All right, August 25th at 9 o'clock.
Thank you, Your Honor. That's all I have.
All right, thank you, Mr. Hardy. Mr. Cobb? Sure.
Mr. Brown?
Which
This is
Mr. Brown is
State
that? I think we've
versus-
got several on the docket.
State versus Robert Brown, 2025 CF 355.
Robert, okay, go ahead.
Need to make a little modification here really quick. Judge, can I approach?
Yes, sir.
He's going to withdraw his plea of not guilty, enter plea of no contest to the reduced charge of misdemeanor DWLSR versus the felony DWLSR, and he'll be adjudicated guilty and sentenced to time served in the Okaloosa County Jail.
What would court costs be on a misdemeanor driving unsuspended? I think it's $300. Okay. I know it's not the normal $270, so. All right, is that the state's, well, it's time served plus the court costs, and that's just going to go to judgment? Yes. Okay. Is that the state's agreement?
It is, Your
Honor. All right, Mr. Brown, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Darrell Brown, 3872.
All right, and Mr. Brown, you're here in 25 CF 355, currently charged with felony driving while license suspended. Do you understand that?
Sure.
And do you understand that that charge is punishable up to 5 years in state prison?
Yes, sir.
And I've been handed a plea and sentencing agreement that calls for you to plead to a misdemeanor driving while license suspended, which is punishable up to 11 months and 29 days in the county jail. Do you understand that?
Yes, sir.
Terms of that agreement seem to be that it would be time served, $300 in court costs, and that would go to a judgment or civil lien against you.
Yes, sir.
Is that what you want to do today?
Yes, sir.
Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Or has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
sir.
Do you understand if you enter a no contest plea as indicated by the form that there won't be a trial of any kind?
Yes, sir.
You understand you're giving up your trial rights, which are on page 2 of the agreement that you signed?
Yes, sir.
You understand that you'll be adjudicated guilty of this?
Yes, sir.
And do you understand that you're waiving all potential defenses you may have to the charge?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and what is your plea to the misdemeanor drive-while license suspended or revoked?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. Sentence you to adjudication of guilt, time served, $300 in court costs to go to judgment. Anything else from Mr. Brown?
Thanks, sir.
All right. Thank you, sir. You got 30 days to appeal the judgment and sentence of the court. I do need your fingerprints since it's a drive-on suspended and
Your Honor,
it's...
just so Mr. Brown knows, this is the second time, so any future one would result in automatic jail time.
Roger that.
All right. What else do you have, Mr. Cobb?
Just go down the list, yes.
Robinson?
Yes, sir. Judge, this is State of Florida versus Victor Robinson, 2025 CF 755. I had reached out to the state to see if we could possibly resolve it today with some type of forever time served plea, but the state said Mr. Robinson scores 42 months DOC, so we're not going to be able to resolve it today like I had hoped. It's a fairly new case for myself.
I think it was the first pretrial when we were here last week.
Yes, sir. I was hopeful we could get it resolved. But I'm going to go ahead and, do my due diligence and do depots and stuff like that. So I'm going to ask for a continuance.
State have any objection?
No objection from the state.
All right. August 27th at 9 o'clock, Mr. Robinson will be your next court date. Mr. Cobb will come and give you an update once he was able to do those things he just mentioned.
Next week. Okay. What was that date again, Judge?
8/27.
I'll see you. Okay. See you later. Oh. You want me to have it too? Okay, thank you. Thanks. Okay. Judge, this is State of Florida versus Kevin Russell. The main case is the 2024 CF 119 case. He has two VOP cases that may be tracking with this case as well. But after our court last week, I went to the jail to speak with Mr. Russell, and I explained to him everything that I could possibly explain to him about the motion to suppress that I filed. I went over what I thought was going to happen with that based on some case law. And then I talked to him about the plea offer that was provided from the state. I told him I thought it was a good offer, that he should consider accepting the offer because of his exposure on the trafficking charge. And then I went to see him this morning to see if he decided what to do. And his decision is he wants to fire me. So he wants to schedule a Nelson hearing and argue that I'm ineffective counsel. Is that correct, Mr. Russell?
Yes, may I speak, Your Honor?
Give me just a second.
Yes, sir.
All right. So, Mr. Cobb, you were appointed in all three of these cases?
Yes, sir.
All right. So, Mr. Russell, you're asking for a Nelson hearing where you're saying, you're going to tell me that Mr. Cobb has done something improper and ineffective on your behalf, and then you want me to appoint you a new lawyer, is that
I
right?
feel that he's not fighting for what's right, the law.
Okay. Go ahead.
The evidence was obtained as a...
Well, we're not going to argue the case today, but if you want me to potentially appoint you a new lawyer, we have to set that for a hearing. But what exactly are your claims? And have you put them in writing up to this point?
The thing is...
Mr. Russell?
I have...
Mr. Russell, my question is, have you put in writing what your concerns are about Mr. Cobb's representation?
Yes. Well, I haven't put it in writing, no, sir.
Okay. Just because that helps so everyone's kind of on notice as to what your concerns are. Again, sometimes I research these things in advance if I have something to read, just to make sure I understand it so we can make a efficient hearing about it once we get back.
Yes, the motion to suppress hearing is scheduled for August 28th. We were going to try to see if we could do it on July 3rd a little early, but the state contacted their witness, and their witness is going to be out of town, and she's not available for the July 3rd date. So at least we have the hearing scheduled to take care of it. And the differences between Mr. Russell and myself is I told him I thought the offer was a good offer based on everything that's going on, and he disagrees, and he feels like the motion to suppress will be granted and it'll all be dispositive. But even if you granted the motion to suppress, as I explained to him, he still has his VOPs he has to deal with, and the state could come back and do a VOP evidence hearing. All that is what I tried to discuss with him at the jail on Friday last week, and he's not satisfied with my representation.
But the law, sir, is that me and Ms. Odom do not fall up under the domestic violence battery law.
I think we talked about this a little bit the other day, Mr. Russell. Domestic violence is just changes a battery case just a little bit and how what we normally do with them. For example, in a domestic violence battery case, as opposed to a simple battery case, it doesn't involve domestic violence. It's usually about whether or not we give batter's intervention program versus an anger management course, things like that. It doesn't really change anything. It's not an element of a charge. Okay. The state doesn't have to prove it was domestic violence, just simply that a battery occurred or not. Do you understand that?
Even with the statute, Florida statute 741.28, 2024?
You don't have to give him any.
741.28 is an injunction statute, sir.
You don't have to give him any.
I'm just trying to make sure I understand what it is, because frankly, if we're going to have a Nelson hearing over it, I'd like to be prepared for that particular issue. So, Mr. Russell, tell me what your concerns are. We'll set it for a Nelson hearing on a separate date, because this is not really the docket to do that. But I'd like to at least know what we're talking
I asked
about.
Mr. Cobb, will he go in there and argue the facts that my U.S. constitutional rights have been violated and my amendment rights have been violated, and he told me no.
No, I told him that I would, but I told him that if it was denied, that the offer would be withdrawn and he'd be facing the trafficking charges again.
Okay.
And, you know, as attorneys do, we go over the pros and the cons of any motion, why we file them. I went over all that with him. So he still is not satisfied. And I don't know how to proceed other than sit it for a Nelson hearing and go that way.
I'm just trying to get an idea on what it is, since nothing's been done in writing, so that everyone's on kind of on notice what we're talking about once we get to the Nelson hearing.
Well, wasn't we scheduled for the hearing today for the suppression, sir?
No, it's set for August 28th?
Yes, sir.
Is that what I have? We're here today.
And then we tried to well, today's a docket day as to whether or not we're going to, I think what was discussed, and Mr. Cobb had just said this, is they were attempting to move the motion to suppression hearing up to this week on July 3rd, but the state's witness wasn't available. They have to have at least a week's time to be able to even subpoena somebody, and so if they're not available, we can't really have the hearing. I can't just look at things that you hand me. What is it, Mr. Russell?
Suppression in my deposition of Asia Sprague.
Okay, but those are things that have to be, brought in as part of the evidence that's brought in at a motion to suppress.
Bob's not arguing that for me.
But it's not set for hearing today, that's why. So, and just so you understand, Mr. Russell, attorneys can't pursue things if they don't feel in good faith they're appropriate. So, I mean, he's filed the motion, he's attempted to set it for hearing. Whether you disagree on what case law can be used or what statutes can be used, that's what can be presented at the hearing, and then I'll make a decision as to whether or not they apply and how they apply. So I'm willing to consider everything that you're talking about. It's just, this is not the date for that particular issue. But if you want to set it for a Nelson hearing, I'll consider that. And then there are some circumstances where, pursuant to the Nelson hearing, I may appoint you a new lawyer who's going to start over with you and talk to you about all these same things again. That's what you're looking to do.
I've been here 17 months. It's been a long ride, and
I understand, Mr. Russell, but I need to know what you'd like me to do. Do you want me to set it for the Nelson hearing today?
Yes, please.
Okay. we have anything else that y'all know about July 3rd? Since we talked about it for the potential of suppression. I mean, I can see there's a couple of pretrial detentions, but
That's all I know.
I just don't know if, I know we talked about setting some things that date, but
I remember only that this was the case that we were trying to set, but
Okay.
we can't, and we do have pretrial detention hearings.
all right, would y'all like to do it kind of associated with that time period?
It's
Mr.
okay
Cobb?
for the
Fine.
state.
Yes, sir.
Okay, you want to set it for, we'll just say 1 o'clock on Thursday, the 3rd,
That would be fine.
for purposes of the Nelson hearing?
You
Does
like
that
to
work?
get something in writing, and,
I just don't know how he's going to get it to me that quickly.
yeah.
But then again, we don't have anything else really set that day after our pretrial detention, so we'll have the time to talk about it at that point. I just like everyone to be as prepared and unnoticed as to what we're talking about, Mr. Russell. That's why I've kind of asked the questions. I think I understand it to some extent now, but we'll go through it more thoroughly on Thursday when we've got more time for that particular issue. So we'll set it for the Nelson hearing on Thursday, July 3rd at 1 o'clock after pretrial detentions. Any other issue with that, Mr. Russell? I'm just trying to get it set as quickly as possible so y'all can make your decisions from there. All right, we'll see you back on Thursday then.
Judge, State of Florida versus Lonnie Strahan, 21 CF 1400. I'd just like to leave this on jury docket, jury review. I believe that's not this Friday.
Not this Friday.
Next Monday or
because of
next
the
Friday?
holiday. It's the 11th.
Yes, sir.
All right, July 11th at 9 o'clock. Does he have more than one case? I think
He does. He has I think it's 404.
I've got 1400 is what I wrote down last time.
1403 is the
1403.
initial case. We're just traveling them together, I believe, Your Honor.
Okay, but 1400 would be the one that'd be set for trial.
Yes, sir.
All right, and this is the one where we talked specifically about the July 14th through 16th that you would need?
Yes, sir.
Okay, so it'd be jury selection the 14th, and then 15th, 16th for trial.
Yes, sir.
Ms. Posse, you agree with that?
Yes, sir.
All right, that's what I had written down, because I know, I think we had talked about those dates actually last cycle, and kind of special set this one to make sure it got on those dates. So it looks like we'll go to July 11th. If we're going to have any motions in limine, I'd certainly like to have them heard that day if we can, especially if there's going to be anything kind of really substantive that's going to take more than, a few minutes to handle. That way it's done before we summon, tell jurors if they have to be here on that Monday morning.
Yes, Your Honor.
Yes, Judge.
All right, Mr. Strahan, we'll see you back on July 11th and July 14th. That's for trial.
We're going to spend lots of time together before the trial, I promise. Judge, this is State of Florida versus Cordell Thomas, 24 CF 906. I found out I represented Mr. Thomas last week. I did go back and look at the motion to suppress. I believe that the court asked me to do that. It is a fairly straightforward motion. I don't know if a hearing has already been set on that motion to suppress.
He's trying to,
Oh.
you'll have your time. I just want to know what Mr. Cobb thinks, because he's the newest one to our case.
Yeah, and it won't take me a long time to get caught up to speed to do that. It's
Have you
just
seen the discovery, Mr. Cobb?
No, I haven't gotten the discovery, but I've
And
looked
I
at,
just want to put this on the records, because when it was set with Mr. Kleins, I believe, who had just taken it over himself, it was set for a hearing. The parties had asked me to watch the video. It's the first 21 minutes or something like
Yes.
that. I had done that in preparation for that hearing, and I think when we got here, that's when there was an issue between Mr. Thomas and his counsel at the time, and then I appointed you to take over the case. So the record's clear that I've already seen that particular video. That's the nature of this motion to suppress.
my understanding, it's a motion to suppress based on a stop that is alleged to have gone on too long, and therefore the search is illegal. Correct?
Yes.
That's the motion, yeah.
Yes, okay.
Mr. Thomas?
It was when it wasn't the stop was too long. It's the officer abandoned his mission before he even knew who I was. He abandoned the mission of the traffic stop.
I understand. I read the motion already, Mr. Thomas. I did all my homework on it because we were set for a hearing. And so I know what it is, but we still have to have the hearing.
Okay. Well, can I say something else?
Yes,
Your Honor?
sir.
In this case, Jones versus State.
Okay, we're not going to argue.
I just want to let you know my position of.
That's what we have.
That's what the hearing's for.
And I'll be the one putting forth the position based on your arguments. I don't, unless you want to represent yourself, but it's me that'll be putting forth the positions at the hearing. And I've read the motion, and I intend to represent you and argue it.
I believe the Jones case was in the motion.
Yes.
And if it was, I've already read it, Mr. Thomas. I'll refresh my memory of that by reading it again before the hearing once it gets set. But today was just kind of a placeholder day to figure out how quickly we can set it because Mr. Cobb's only been on your case for a week, 2 weeks.
I haven't seen an attorney in 45 days. It's the same, like I haven't been able to talk. I've seen you more times than I've seen 3 attorneys.
Okay. Well, I think part of the issue with that is you were represented by an agency that had some turnover, and then once we got to the point where there's going to be a hearing, you asked for them to be relieved from your case.
Yes, Your Honor, because honestly, on the video that was showed, he didn't see the same thing that I saw.
Okay.
The same thing that you saw and the same thing that the state saw.
Some people have different opinions when they watch the same thing, but we'll have a hearing where I'll review the evidence again in advance. And hold on, I'll take a look at it, and then both sides will get to come in here. I believe the officer was set to testify 2 separate times. Ms.
Yes,
Leone?
Your Honor.
And he'll come in if anyone wants him to testify, and I'll listen to that, and I'll listen obviously to what you have to say, Mr. Thomas, if you're going to take the stand as a witness in your hearing, and then I'll make a determination as to whether or not what was done by law enforcement was a violation of your constitutional rights, and therefore suppress the evidence.
Yes, sir. And on top of that, I just wanted, like the other depositions that was supposed to be done, because no narcotics were ever found on my possession. No, it was in the back seat of an officer car where I had no control over.
Okay, and I think that's probably more of a factual issue that can be brought up during the course of a trial, unless there's something else I haven't seen. Or again, remember, I only watched the first 21 minutes or so of the video, so I didn't watch all that. Because that's not what I was asked to watch. I'm not saying I wouldn't if I was asked to, but I didn't want to watch things that could then potentially prejudice you on the first issue by watching things that happened subsequent to that.
I understand that, Your Honor. The depositions that was needed to be done by the first deposition that was done did not ever get the officer on record saying when did he abandon the mission. It was never asked. The question that was never asked on the record.
So what are you asking for, Mr. Thomas?
I wanted to get the officer on record saying when was it that he chose not to write the ticket? Was it before or after he asked me for my identification?
I understand. I
what
think
wanna get
the
on
video
record.
is clear. I mean, the video is going to be the best evidence of that, right?
Yes, sir. But that's why the depositions wasn't took by Mrs. Flowers, I guess, because the video was the proof that he abandoned the mission before he even knew who I was.
I understand, sir. But today's not the hearing, so
I just wanted to get it on record.
Well, it'll be on record. Maybe on record when people raise their right hands and swear to it as far as evidence.
Yes, sir.
Or that video evidence gets admitted. It may have actually been admitted as part of it, so that I could look at it. But the parties had stipulated that to have me watch it. So.
Judge, do you want me to contact Ms. Guzman about a new suppression date, or how do we want to go about doing that?
Ms. Leone, do you have any suggestions on dates?
The dates that I know, Your Honor.
I know that we have that July 31st date is.
That I cannot do.
That you can't.
That I cannot do.
It seems like several people in your office are out of town that day, but we have a pretty big docket as it is as well. So.
I mean, I'll have people covering for.
Why don't we do this? We'll set it for another pretrial conference, but work on a date that we can maybe get something earlier than that.
Yes, sir.
Obviously, y'all know, I don't know what we're going to have as far as trials after today. If there's a day that's open after that, during the trial weeks, I'm happy to do it during those days as well. But I just don't have a whole lot of days between now and that July 31st date, Mr. Thomas, because we've got 2 weeks set aside for trial and a lot of other work that goes up into getting things ready for those trials.
Yeah, and really technically, I agreed to take a look at it to see if we could move faster than normal. But, you know, with all right, I have the right to slow things down and take my time to do it. I don't want to rush. But if we set it for August 27th, I'll try to get a date before that we could have the suppression hearing. I don't want to.
I expect we'll get a date before that.
Okay.
It's just a matter of seeing how the rest of today pans out, Mr. Thomas, because I think I had 20 cases set for trial for those 2 weeks.
I understand, Your Honor.
That doesn't mean all 20 cases are going, but we just want to make sure that if there's a date available during that time, I'm happy to do it.
Is it like before then, Your Honor, if we can I can talk to my attorney and he can talk to the state to find out if we can resolve this before.
I'm sure they'll engage in that as well. See,
Before we can.
most lawyers have to work on these cases on several different tracks at the same time, which is if there's a motion to suppress, working on that issue, working on a potential plea, thinking about the potential trial. So all those things are kind of done in conjunction with each other, Mr. Thomas. But you got to give Mr. Cobb a minute to catch up, since he hasn't even seen the evidence yet, and that's probably why he can't come to see you to talk about it, because he's got to get it and review it first. I mean, he just found out about your case, I believe, last week, right?
Yes, sir.
All right, so 7 days ago is when he found out about your case.
I understand that, Your Honor. This is just self-explanatory, really. It's been this since we.
Well, it's not self-explanatory, because you have to present your side and the state has to present its side, and I'll make a decision on it based on what you present. It's not just about, hey, judge, go watch the video and figure it out for us. Y'all have to make your arguments.
Yes, sir.
And frankly, maybe Mr. Cobb looks at it a different way than the previous 2 or 3 counsel that you had on the case, and y'all work something out. That's all up to you. But I'm going to put it on a pretrial date with the idea that a new date's going to get set on the suppression hearing before that. I just can't give you one right now, because if I give you one now, it's probably going to be later than you want. And I'm trying to see if something will open up earlier than that, Mr. Thomas.
When will Mr. Cobb be able to?
You have to talk to Mr. Cobb. I don't control his calendar.
When you come see me?
Next week.
Mr. Cobb has several other cases on this docket, including one that's set for trial.
It's a short week as well,
And
too.
it's a short week, but we have an extra week. And that's why you said you could do it next week.
Yes, sir.
Not this short week. All right, so Mr. Thomas, I'm going to put you on that August 27th pretrial date, but I expect we'll have you back before then on a suppression hearing. August 27th at 9 o'clock.
Don't get upset with me, because I just got the case. I'll come see you. Just
Okay.
I know. I'm going to come down and see you about it. I'll see you.
I'm short. That's all you got, Mr. Cobb?
Yes, sir. Thank you.
Thank you.
Hey, Ryan.
All right. This is Mr. Norris, 21 CF 2144.
It is, Judge. The state's going to email me their motion in limine. I'll review it, file any motion that I think is appropriate, and I think we're still on track for a trial.
We are. Judge's state is ready for trial. The state has filed its motion in limine on June 20th, but it hasn't posted to the clerk's website yet. So we have.
You could send a courtesy copy to my office. So.
I will do that immediately. And we will be filing a Williams rule motion, but we don't anticipate it to take very long. The state did want to let the court know that it will be in an all-day motions hearing on the 11th, this court's jury review day. So I will email the court and Mr. Williams to see if there's another time we could perhaps hear those motions. Or I'll see if I can get coverage from another person in our
How long
office.
do you think those motions will take?
If I proffer the evidence to the court rather than taking testimony, probably an hour.
The concern is next week, which is kind of our extra week that we happen to have between docket day and trial, I'm on duty. So I've got hearings set every morning in civil cases, and I leave my afternoons open so I can make sure to accomplish all the tasks of the duty judge. which sometimes isn't a whole lot and sometimes is overwhelming. So we just don't know until we get to the particular day. So I could potentially try to squeeze y'all into one of those afternoons, but if it's going to be 4 hours, I can't really do that.
No, I don't think so.
Judge, we'll talk about it, try to narrow down the issues.
Let me just take a look and tell you what might be the potential best out of them. Well, communicate with my office, and Ms. Guzman will give you an idea. Thursday, we have a felony plea date that afternoon, and some other cases, I believe, set. So Thursday would be probably out at this point, so we'd have to special set it for one of those other days. So probably the 7th, 8th, or 9th.
All right, Judge.
Has the Williams rule motion been filed?
No, I plan on filing it later today.
Okay. Make sure you, again, send me a courtesy copy so I can read it in advance.
Of course. I'll send both in one email to everyone.
All right, so anything else from Ms. All right, I guess while we're here, talk about trial dates. How long do y'all think it'll take trial-wise?
Judge, the stand your ground hearing took
2 days.
2 full days. I think we've always talked about this as though it was going to be a week-long trial.
Okay. Well, at this point, it'd have to be the first week then. Have we talked about that previously?
I was kind of told to expect the second week, but I got that sort of second or third hand from Ms. Leone because I think she was planning on doing her trials the first week.
I mean, I already have a 2-day trial set that we set last time.
For the
July
second week.
14th through 16th.
I think if, including jury selection, if there's not a lot of rebuttal, we could take 3 days.
Judge, I normally can try a case fairly quickly.
Okay. Well, again, the stand your ground hearing took 2 days on its own after it was set for 4 hours. So I'm not trying to say anything against either party. I just want to be realistic about it as well. So although I think a good portion of that was me watching the video, but I guess I'm not sure if y'all are going to try and use that entire video. I'm not asking that at this point, but
Yes, sir.
that video alone was over 3 hours, I think.
Yes.
And I think there was videos I probably had seen based on that there was some still shots from body cameras and things like that. So I'd rather y'all have as many days as possible, but talk about that before next week so we have an idea. Then obviously after today's done, I'll have a better idea on how many trials I'm going to have and if I'm going to have to try and get fill-in judges to help out.
And I'll check with my witnesses too. I believe their availability is both weeks at this time, but I'll double check, just make sure nothing has changed.
Okay. All right, because obviously I don't want it to do a switch on who your judge is or who another serious cases judge is at the last minute after all the things that we've had, especially in this case. Again, I would make your case, Mr. Norris, more of a priority because of the amount of work that I've been involved in the case in just the 6 months that I've had it. But we'll have to figure that out with the other ones that we have. Again, I had 20 set. I think the last time we had 24 set and 1 went. So sometimes we'll have 5 set and all go. It's just we'd have to figure that out by the end of today. All right, so I'll see you back on 7/11. That's July 11th, next Friday. There's probably going to be a motion hearing before that. We just know what that date is until they coordinate it.
Yes, sir.
Any questions, Mr. Norris?
No, sir.
All right, we'll see you back on those days. Still set for ready for trial.
All right.
Thank you.
Did you have anything else, Ms. Chandler? Sandler?
Oh, I have nothing.
Okay. All right. Mr. Nopes.
I've got one case, Boy, 24 CF 2540. Judge, the state and I have more or less got this taken care of. It's just that she needs to make a phone call and speak with her victim.
Yes, we do have a resolution. I just need to speak with the victims about it.
Okay, so when do we think we can bring it back for that purpose?
Maybe just for a control date, any miscellaneous, even before pretrial, Your Honor. We shouldn't need more than this week.
Well, do you want to put it not just on the jury review date, the 11th?
That would be
and see
fine.
if we can resolve it that day?
What is
If
that
it's-
date, Judge?
It'll be resolved
That's
before
next
then.
Friday.
Yeah, yes, Your Honor, that would be fine.
Mr. Nopes?
Next Friday would be the 11th. I'm out of town.
Okay.
Sorry, going to Vegas, Judge.
Mr. No, let's leave it set because I will do,
Okay.
yeah.
Okay, that's fine.
It's okay, Your Honor. Worst case scenario, we can,
If I have to,
Just
Judge,
go-
I'll just get somebody to cover for me.
yeah, because,
But I think it's going to take care of itself.
Okay.
may we approach?
Sure.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured.
All right, so let's set it on that July 11th date at 9 o'clock for control.
Very good, Judge. Thank you. That's all I've got.
All right, thank you, Mr. Nopes.
Have a great day.
You too. Mr. Browning, you just have one? All right, go ahead.
Court Branford, Cody Ladner, 24 CF 2833. Judge, we let it set today, try to work out this straight PTI. Because my client lives out of state.
Mississippi, right?
Yeah, Mississippi, yes, Judge, good memory. I've not had a chance.
It's not my memory, I write things down.
And we've not had a chance to get with probation, Judge. I'm thinking that we may have to enter a plea into PTI in order to, I think probation's position probably comes under the interstate compact. I'm just asking for a date, a few weeks out. If he has to plea, I'll have to bring it back.
Well, let's do this. Let's set it for the next pretrial. That way, if he doesn't have to plea and y'all can handle it by paperwork, when that trial, that date will fall off.
Okay.
Otherwise, if it's got to be a plea, we can either do it on that day or you can bring it up through another day that you work out with the clerk's office or my office.
Yes, sir, that'll work.
All right, so I'm going to put it on the August 25th pretrial date for the PTI. I know, obviously, when we're dealing with things out of state, I always make sure, back when I was in your position, Mr. Brown, talked to the probation to see what hurdles there were going to be so we can hopefully resolve those before the plea happens and it turns into a mess. So, all right, thank you, Mr. Browning. We'll see you back on that date. All right. Mr. Kleins, are you ready with yours? Mr. Tony? I'm not sure who was here first.
I wasn't here first, but I'll go. I just have one matter, Your Honor.
Okay, and I think this is the one it was just kind of a where are we at with getting depots set?
Yes,
Announce the case, Mr. Tony. I'm trying to find it.
State of Florida versus Kevin McKinley Sr., 2024 CF 1580.
All right, go ahead.
With regards to this matter, Your Honor, we've set the depositions, and I think they're set for September, I want to say the 26th or somewhere around that time.
26.
That's correct, Your Honor. That's when we were able to set them.
Is that everybody?
And I'm going to have to drop a couple of them, Judge, because I don't think we're going to have enough time in that slot to get all the.
I just want to know if this is a situation we're going to come back again to say we've got more depositions, because that case will be a year old like next week. So if there's more to do, I just want to make sure it's set.
There's more work to do on this case.
Okay. So why aren't those being set?
I don't know how long we're going to have for each individual one, because I'm still having an issue that I'm with the warrant that I'm going to have to probably file something on.
Okay. Well, is something going to get filed on that and heard
Yes.
before that date?
Yes. So we'll probably have a hearing before that.
And that's the unseal, right?
Yes, Your Honor.
I want to put it on the August date just as kind of a status, see where we're at, and if anything else needs to be done, or I need to give you another court date for the motion.
That's fine.
Well, yeah, he hasn't filed the motion yet. Have you filed it
That's
yet?
what I'm saying.
Yes.
Because if we, I'd like to at least check in on it on August 25th, which is the next pretrial date.
Oh, yes,
Find
yes,
out, hey, is there going to be another motion? Are there going to be more depositions done? That
Yes.
way, I'm kind of actively managing this, which is, the role that we've been given.
I think it's fine to set it for next pre-trial, Judge.
All right, 8:25 at 9 o'clock, Mr. Tony. Let's try to get everything set up for that date. Is that all you had, Mr. Tony?
Yes, sir. 8:25, that was this?
Yes. August 25th, 9 o'clock.
Yes, that's all I have, Judge.
All right, thank you.
Thank you.
All right, Mr. Kleins.
Custody. Barbara Adams?
Abrams, I thought.
I thought it was Abrams too, Your Honor. She was here last week, and I specifically passed this over to today so I could give her a copy of the mental health plea agreement. She doesn't have a phone, and so I don't know how the court wants to proceed.
Isn't Mr. Maddox on one of her cases?
He has
too?
one of the cases, Your Honor. He has the 505 case.
Let me maybe see if he's had any contact with her. Mr. Russell looks like he's jumping.
I
up
talked to
a
him
little bit.
earlier, and he was asking me if I had contact with
All right.
her, so.
Stand down, Mr. Russell.
So I don't know how the court wants to proceed. I mean, she was here. I gave her, I believe I even wrote it down on the next court date piece of paperwork, just so I could have her here, because I can't have contact. There's no way I can
I think
have
you
contact.
talked about that last time.
Correct. So I don't know where she's at.
What was it was going to be mental health court?
Yes, Your Honor.
So I've already talked with Ms. Sharpless also, and as a matter of fact, this was what I was going to give her
Make sure
today.
she's the state attorney who handles mental health court.
Correct, and so I was shooting to have her plea in to mental health court on July 16th. The issue is she's not going to know about that court date if she's not here. So I don't know how the court wants to handle that.
It's the state's position.
Get capious, Your Honor. Ask for. And then hopefully if she shows up today, we could remove it.
I can't, in good faith, argue against that. I believe that probably what the state would do is once she's taken into custody, we could plea her into mental health court as quick as we can get her on that docket. Having no way to get in contact with her, I don't see how the court couldn't issue a capious at this point.
Well, I understand, but my concern is like sometimes I'll do a capious and then they're given the court date to show up, but we don't even know when to set it at this point.
The only thing I would think to ask would be if the court's going to issue a capious, set some kind of a signature bond so that she is notified in jail with her next court date.
Well, what I'm going to do is I'm going to do a capious, but set bond at first appearance so they can maybe get pretrial supervision that could be in place that would get her to stay in touch with them and therefore be easier to reach by you, Mr. Kleins.
She's one of the few clients that I've ever had who just point blank was like, I don't have a phone number, like not even trying.
Not even like an email or anything either?
I have no way to get in. As a matter of fact, I think last week was the first time I'd ever said hello to her because I came in, my first day in this job was the first docket day of the last cycle. and she'd already been continued, so.
You'll approach.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been.
All right, so what I'm going to do is a KP is set bond at first appearance. And then whatever day we can get that in, or if you can plead it out in mental health court faster than you can do anything in my division. But I'm just worried because once we get that trial period, we're going to be pretty busy.
And so the court's aware, I look at who gets booked and released every single day. So if I see her hit the jail, I'll know she's in custody right away.
All right. And if it's something we can just bring in for a 5-minute plea, if it has to be in front of me, or if you can handle it through mental health court, I'm fine with that as well. I know that was the intent when we talked about it last week. Whatever gets it done more efficiently.
Yes, sir.
All right.
Yep. Yep. Your Honor, this is Mr. Kelvin Brown. He's before the court on 24 CF 2757. We had left Mr. Brown on today to see if there was a way we could get this resolved. I think we're on the cusp of an agreement here. For today, I'm going to ask the court to continue this one cycle. However, I just advised Mr. Brown, I told him this at the jail last week. My goal is to get this, if we can get this resolved in the month of July, I want him back before the court as quick as I can. So if we can continue it, however, the goal is to have Mr. Brown resolved here quickly, if possible.
No objection from the state.
All right, so what I'll do is I'll put it on the August 25th date, and then whenever y'all are ready to resolve it, bring it in for an earlier date.
Would the court, I'm sorry.
Go ahead.
Would the court authorize me to place him on a pretrial detention docket if it's going to be an early plea?
Yeah, I'm fine with that.
Okay.
I mean, to be honest, if it involves someone doing more time because I can't give a date, we'll find a sooner date.
Okay.
Even if that's, if we've got a trial date when you want to come in at 8:15 in the morning and plead it out, if it involves Mr. Brown being released or going on his way to whatever else he has to do after this case, I'm fine with that.
Yes, sir.
I just don't like the idea of people waiting around for 2 weeks just because my schedule is busy. So I try to find other ways of getting that done.
I do appreciate that.
All right. Thank you. So August 25th, and then we'll see whatever date we can get earlier than that, Mr. Brown.
All right, man. All right, man.
All right.
Your Honor, this is Mr. Donald Hanish. He's pretty much in the exact same boat as Mr. Brown was. Both of these individuals score presumptive DOC sentences here. We're trying to work on alternatives to prison. The state is willing to consider, with both Mr. Brown and Mr. Hanish, something that doesn't involve the Department of Corrections in a custodial situation. So I would ask the court to put Mr. Hanish on for the August 27th date.
I'm sorry. Go back. On Mr. Brown, it should be the 27th, not the 25th. That's, if y'all are, we do non-inmates on the Monday and inmates on the Wednesday. So you got to correct me if I get it wrong. No, you're right. I mean, but I'd rather say no because of this issue. It's not that than get it wrong and have to go back and fix it. So. Regional council goes in the morning. Because to be honest, we typically finish pretty early in the morning.
Yes, I would appreciate that. So Mr. Hanish is the same boat. I'm trying to get him back before the court sometime in the month of July to work on a resolution here with both of
from
these.
the state on that?
Yes, State's fine with that, Your Honor.
Okay, so Mr. Hanish, it'll be August 27th will be your next pretrial conference date, but if they get a resolution, they can bring it in sooner than that. All right, thank you, sir.
Comes out to you, okay? Your Honor, this is Mr. Scoffield. He is signing a plea agreement right now to resolve these 4 cases. Today is 6:30. At this time, Mr. Scoffield is going to be entering a no contest plea as charged in 24 CF 1844 and 24 CF 2080. In exchange for the pleas of no contest on those cases, the state will null pros 25 CF 398 and 25 CF 495. The agreed-upon disposition for Mr. Scoffield on those 2 24 CF cases, he will be sentenced to time served concurrent. He will be assessed $615 in court costs per case. There is one $50 application fee, a $100 cost of defense per case. In 24 CF 2080, the court will award restitution of $43.98 to Circle K. Mr. Scoffield has previously been adjudicated. He will be adjudicated on these 2 24 CF cases. As part of this agreement, the state will agree to take no action on any failure to appear in any of these 4 cases. May I approach?
Yes, this is the state's agreement.
It is, Your Honor.
All right, so this is going to be a downward departure then?
Yes, it is, Your Honor. Based on
Mr. Scoffield, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, can you state your full name and date of birth, please?
Robert Jeffrey Schofield, date of birth 1/10/87.
All right, thank you, Mr. Schofield. Mr. Kleins, just to put it on the record, I know there was a situation with prior counsel for Mr. Schofield about a potential competency review, but I think you brought this up last time that in your discussions with Mr. Schofield, you didn't have any concerns about that.
I have none.
Okay.
He just is passionate about his defense, which I appreciate.
And I understand that, and I just want to put it on the record that it's not a concern of yours. And obviously, Mr. Kleins, you've been doing this for quite some time, both in the PD's office and now with RCC. So I certainly appreciate your comments on that. All right, so Mr. Schofield, I've been handed a plea and sentencing agreement that would have you enter pleas of felony petty theft, which is a 3rd-degree felony punished by up to 5 years in state prison, 1 count each in 24 CF 1844 and 24 CF 2080. Be time served, $615 court costs per case, $50 application fee, $100 cost of defense per case, $43.98 restitution to Circle K in the 2080 case. And in return for that, the state's going to dismiss 25 CF 398, 25 CF 495, and then state's going to take no action on any potential failures to appear.
Yes, sir, Your Honor.
Is that your understanding of the agreement that you've made with the state?
Yes, sir, Your Honor.
And that's all the state's agreement, including the downward departure? Okay, because I'm looking at the guideline sentence that shows that he scores 20.175 months. The Department of Corrections as a low as permissible. What is the reason for the downward departure? Okay. And Mr. Schofield, one thing I didn't mention, but your attorney had, is that you'd be adjudicated guilty, so these would be felony convictions of petty theft. Do you understand that?
Yes, sir, Your Honor.
Is this what you want to do today?
Yes, sir, Your Honor.
All right. Have you had enough time to speak with your lawyer about it?
Absolutely.
I just know he's been recently got on your case, and I want to make sure that you've had all the time you need.
Yes, sir.
Okay. Did you go over the plea and sentencing agreement with him?
Yes, sir.
Okay. Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir, I did.
These are just all the questions I ask every time someone enters a plea. All right. And are you satisfied with your attorney's advice and representation?
Absolutely.
All right. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, I'm not.
Are you currently suffering from any mental health issues at this time?
No, sir.
Okay. And has anyone forced, pressured, or threatened you in any way to enter these pleas?
No, sir.
And has anyone promised you anything in return for these pleas?
No, sir.
Do you understand by entering a plea of no contest, as indicated by your form, that there won't be a trial on any of these charges?
Yes, sir.
Okay. You seem relieved by that. Okay. And do you understand that you're giving up your trial rights, which they start on page 1 and continue over to page 2 of that agreement that you signed?
Yes, sir.
And do you understand that you're waiving any potential defenses that you may have in these cases?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
Ask it to everyone, Mr. Schofield. All right. And what is your plea as to the 2 counts of felony petty theft in 24 CF 1844 and 24 CF 2080?
Plead no contest, Your Honor.
All right. And I'm going to accept your no contest as freely, voluntarily, knowingly given in those 2 felony petty theft charges. I'm going to give you time served, concurrent, $6.15 court cost per case, $50 application fee, $100 cost of defense per case, $43.98 restitution to the Circle K in the 24 CF 2080 case. State have an announcement in 25 CF 398 and 495.
The state will null pros both of those cases, Your Honor.
And Mr. Shi, can you also, as the state, because it was talked about the state not taking any action on any potential failure to appear in any of these cases, is that accurate?
That is accurate.
Okay. All right, Mr. Schofield, I've announced your sentence. Mr. Kleins, as far as monetary issues, how do you want that to happen? Do you want to give him a chance to set up a payment plan or just go straight to judgment? I think I said adjudication of guilt. If not, I'm saying it now.
Your Honor, he would request that the court give him 60 days to set up a payment plan.
Okay. Do you expect to be released today, Mr. Schofield?
I hope so.
Is there anything else holding you from any other county or something like that?
No,
Other
sir.
cases in different divisions?
No, sir. I don't think so.
So I'm going to say 60 days from your release, you have to either pay these or set up a payment plan with the clerk's office. Okay? If you don't do that, they will be sent to judgment against you.
Okay.
Yeah, can't get arrested, but.
All right. Anything that, and this is a downward departure pursuant to an uncoerced plea bargain between the state and Mr. Schofield. He scored 20.175 months, but has been given time served, what I think is probably, about 4 months, 5 months?
Give or take, it was right around 4 to 5. I mean, technically speaking, if he was arrested last year, it's right around there.
120.
I'm just so it's clear for the record, I don't have the exact date. I'm not looking at them doing that off of memory. So
He's been in custody since February.
Okay, that's what I thought.
And he also had about a month prior to that as well.
Okay, so 4 or 5 months, like we talked. All right. Anything else that I've missed? All right, Mr. Schofield, again, you've been adjudicated guilty. I'm going to need your fingerprints for those 2 cases, and you have 30 days to appeal the judgment and sentence of the court.
Thank all of you. Thank you, Mr. Barkley.
Good luck, Mr. Schofield. We'll take that one off the trial docket.
Your Honor, this is Gregory Spears. He is approaching the podium. The state has made Mr. Spears, frankly, 2 different offers. The offer from the state would be to dismiss both of the 24 CF cases, the new law violations, if Mr. Spears admitted to violating supervision in the 212 CF cases. The reason why I say there's competing offers is because the state has made either he waives all of his prior credit and starts a new 24-month Department of Corrections sentence with no credit, or he pleads to 74.1 months in the department with credit for all time served. Mr. Spears is still trying to run the numbers to figure out what might get him home sooner. He needs to speak with his family. He hasn't had a chance to do that yet. Ms. Leone today asked if the defense would be open to putting this over for jury review, so there's a deadline on this offer from the state. I don't personally have an objection with that, knowing that Mr. Spears is not going to be set for trial this cycle, so he wouldn't be on the review for a trial date. It would just be, are you taking one of these offers, or are they being revoked and this being set for hearings?
So for next Friday, you're talking?
Correct, the 11th.
For the 11th, Your Honor, yes.
Is that state's?
It's correct, Mr. Kleins is correct, yes.
All right, so hold on, Mr. Spears, just a second. I got to announce a couple of things first. So if it's not resolved on the 11th, we'll just put it on the next pretrial?
Correct, Your Honor.
All right.
Either that, I'll be asking to be set for a VOP evidentiary.
Okay.
One of the 2.
All right.
Yes.
Probably both, actually. So, Mr. Spears, we're going to put you on for next Friday, July 11th at 9 o'clock, hopefully to resolve the case. Otherwise, we'll set your next hearing from there. All right, thank you, Mr. Spears.
I'll see you next week. Oh, sweet, thank you. All right, Your Honor, this is Mr. Hernandez. Mr. Sheik just handed me the witness list. I did get the discovery between today and last week. But I have the witness list now, so I will get these depositions scheduled. We'll start working on that today. I would ask the court for a one-cycle continuance to the
Very new
August
case.
20. What's that?
It's a very new case.
Yes, to the August 27th date. Mr. Hernandez was just inquiring about a potential bond motion, so I told him I'd come to the jail and talk to him, and if we can get that notice for an earlier date, we'll go ahead and do that.
And if you could, Mr. Kleins, I'm showing this case is coming up under Ms. Jaquit's.
I believe we filed a notice of appearance last week.
Probably just hasn't been processed before my
Right,
docket was put in.
I know that we filed a number of notices of appearance last week to try to clean up the docket, so.
It just makes it easier for me to go back and forth between the different dockets and notes and.
It's throwing me off too.
I think there was one with the Abrams too. I don't know if that was.
Oh, was there? Okay.
Yes.
If we could just make sure those get cleaned up. I know Mr. Maddox had one of the Abrams cases, but for Mr. Hernandez, we're going to put you on the August 27th date. If a motion for bond gets set, that can be set for an earlier date potentially. I just don't know what's available by the time we get to that point.
Thank you, sir.
If there's a day available, we'll put you on it.
See you next week, okay? Okay, all right.
Let me just make sure. Mr. Kleins, do you have any others?
Okay, show me when I do. No, I don't, Your Honor, I'm sorry.
All right.
Thank
Thank
you.
you.
Excuse?
Yes, sir.
Thank you. Have a good week.
All right, you too. Let me just take a look at some of this. All right.
You too, Scott.
Your Honor, you're doing pretrial detentions this week?
Yes.
Okay, up here? I
I know. Since you've been involved, there's been kind of a lot of substitutions, but it should be pretty straightforward going forward.
Okay, I expect to
Because
see.
I think you got appointed one from last week. That's why it got continued.
Correct, and I'm taking the rest of the week off, but I will be here on Thursday for the detention hearing. So I just want to make sure it was here.
Yes, it'll be here in front of me. I think we have an arraignment docket after that as well.
12:30, right?
Or not? I can't remember. We have an arraignment docket this week, or is it next week? It's next week. Never mind. So there shouldn't be much on that docket.
12:30 Thursday?
Yes, sir.
All right,
12:30.
awesome. I'll see you in a couple days.
All right, I've got the Jason Howard case on the docket. Is he? Okay, so we'll address that later then. All right, then we've got Mr. McDonald. Let me see what else we have. The only other no attorney I had was Anita Redden. Is Ms. Redden here? Okay. The state familiar with this case? Anita Redden. It's a petition for expungement. I'm not sure why it got put on this docket, but it did. You live out of state, is that right, Ms. Redden?
Yes.
Okay. I saw that this morning when I was going over the docket, and I was like, what is this case? I don't remember this name. And I saw you had filed something a couple of weeks ago about needing a different court date, but for some reason that never got sent to me.
Right.
So,
Well, Your Honor, I don't know if things have changed recently about, when the state approves a request for expungement.
yes.
I know, and I don't remember if it was this case, Your Honor, that when Ms. Guzman, we sat for an hearing because there were victims involved.
Yes. That's
Is it a
typically why
different
it's
case?
done, yes.
Was that a
Anytime
different-
there's a victim involved, we have to get the input from them before an expungement or seal can be done.
Yeah, so should, I guess, set this case for a hearing where I can inquire with the victim?
I actually have a notarized statement from the victim, which is my daughter's father, which he
Okay.
said he has no issues with me getting my expungement. Like, it's been 14 years. My daughter's 14 in 2 weeks. He's moved on. I've moved on. Actually, him and my daughter are in Disney right now, And that's why he's not here, because they went on a family trip, and I couldn't go because I had to show up here. But he did write a notarized letter that I could present to the court. And he said he did speak to the state attorney and told her several times that he
Well, that may have been a different state attorney a long time ago.
No, this was just like June
I can
10th.
do
All
I
right,
have time?
do you want to take a look at what
Yeah.
she's got? And then, Ms. Redden, why don't you take a seat, see if they can verify those things? Because when you say he's talked to the state attorney, it could have been the receptionist, a legal secretary, a victim's advocate. They had, so they'll verify what they have in their system. I'll call you back up once they've had a chance to do that.
Okay, thank you.
Thank you. All right, McDonald. All right, Mr. McDonald. Obviously, we were just here last week, and there was a lot of issues that we had to talk about, and one of your issues was about standby counsel.
Yes.
Where are you at? Because I think last time you discussed it with one of the public defenders. That mean you, Mr. Russell, I think went and talked to you about it? Explained what standby counsel and how that works?
Yes, he did, Your Honor.
Okay, and so how would you like to do that today? Is that something you still want to pursue?
No, sir.
All right, so you just want to go forward and represent yourself?
Yes, sir.
Okay, and I've talked about this before. I don't want to go too far and question you about your ability to go forward as representing yourself. I know we've talked about that. I haven't had a chance to look at it, but apparently that case that came out recently that told us not to do that may have had a rehearing and a new order. So I'm going to go take a look at that when I get a chance.
All right.
But I know you brought it up after I brought it up one time that you thought I might be trying to push you towards having counsel. I certainly don't want to give that impression to you, Mr. McDonald, but I also don't want to make sure that's what you're telling me you want to do.
Yes, sir, I do.
Okay, so, because I've already done the Ferretti hearing quite some time ago, and I'll take a look at that, but do you feel comfortable going forward by yourself today?
Yes, sir, I do.
And just make sure the record's clear, again, we talked about it last week, but you would ask for standby counsel, but after discussing that with another lawyer, you decided that you don't want standby counsel and are ready to proceed as on your own?
Yes, sir.
Okay. So what would you like to talk about today as far as what needs to get done on your case going forward?
Well, today we're supposed to be here to provide you with the names again for the depositions.
Okay.
In both.
And did you have those in writing like we talked about, so you can hand that list over?
I have the names to give you, Your Honor, from the discovery from the state. If you would. Because that's the way we did it last time. You wrote them down, and that's, so I.
Well, I understand, but things have changed, and I just want to make sure that's the way. And don't take it personally, Mr. McDonald. If I ask you a lot of times, is that sure what you want to do, or I want to make sure you haven't changed your mind. I'm not trying to be difficult. I just want to make sure that you've had enough time, or that you feel comfortable telling me, Judge, I've changed my mind since the last time we were here.
Yes, sir.
All right. All right. And go ahead.
So for the record, Your Honor, for CF 1950.
Hold on a second. You're missing part of that. So that's 24 CF 1950.
Yes, sir.
Go ahead.
There is one issue with this I would like to address before I gave you the names. On April the 30th, Your Honor, I showed you briefly in which you stated that, you couldn't understand me showing you something for just a momentary glance at something. There's two EMS officers that were not listed on the discovery.
Watch the microphone.
The discovery exhibit, Your Honor.
You were hitting it, it was making noise. So.
I'm sorry.
It's okay. I just want to make sure I can hear
I
you.
want to address that because the state is using the, I guess, the medical aspect of the heart rate and stuff like that.
Whose heart rate?
Mine, in the EMS, because they're saying that I tampered with evidence, and they're using the EMS records to prove that fact.
Okay.
So, but they're not listed in the discovery.
What's not listed?
The names of the EMS officers.
The names of the EMS
Yes, sir.
people.
But I do have them.
Are they in the reports?
They are in the report. They were in the discovery, but not listed in the amended discovery.
Let's just deal with one issue at a time, Ms. Leone. Are you aware of the EMS people and as to whether or not they're in any discovery exhibit listed as a witness in what category?
No, I'm not aware whether or not they are listed. However, as he has announced, we've shared the documents. He is on notice of those two people.
Well, I understand,
Yeah.
but as far as setting depositions, it depends on what kind of category they are as to what
Yes,
he
they are
can do
not
a
listed in the
deposition on. If they're not listed, he can't depose them.
I'll have to review that, Your Honor. I don't know.
Okay. All right.
Shall I give you the names?
Yes, what are the names?
The first EMS officer's name is Bain Burgess.
Dane?
Bain, B-A-Y-N-E,
Okay.
Burgess, last name.
I've got it. All right. And who else?
Okay, and the other one is Sydney, S-Y-D-N-I-E, Madsen, M-A-D-S-E-N.
So you want to depose those two people?
Yes.
But they're not listed in a discovery exhibit. Do you have any concerns with that, Ms. Leone, if they were in the report?
Well, as Your Honor said, I would have to see what category type of witnesses are, because if, for example, if they're category C, he cannot depose them.
I understand, but they're in the reports that you've provided, and the
Right.
names aren't in the discovery exhibit, so, you know, he's being prevented from setting these depositions because they haven't been included properly.
Right. And I'm saying, okay, if he wants to depose them, that's fine for the state.
I'm not trying to strong-arm you into that, Ms. Leone, I just want something to get done on these issues.
Right, I was just saying, it may not be necessary to depose them, but if I can agree to it, it doesn't.
I haven't seen the discovery, so
Yeah.
I don't know who's, what category and vital or not, so. All right, who else?
All right, the state has listed an expert witness, Jessica Bosseler.
You know who that is, Ms. Leone?
Yes, it's from FDLE.
Okay.
Jessica Bosseler. All right, and then their category A witness.
Oh, okay, hold on just a second. So you want to depose someone, where is she stationed?
Pensacola.
Pensacola.
I'm sorry, Your Honor.
I'm just asking for purposes of setting these things up. Because as we talked about last time, Mr. McDonald, since you're incarcerated and be doing the depositions yourself, we have to find a place for you to do that. We talked about doing that at the courthouse. But if she lives and works in Escambia County, she's supposed to be deposed where she's resides or works for her position.
Yes.
So does the state know if she'd be willing to do an Okaloosa deposition? Have you talked to Ms. Vossler yet?
No, Your Honor, I don't even know that you wanted to depose her, so yeah.
I'm
haven't.
just asking the questions because it's not like we can all jump on a Zoom call tomorrow and figure these things out. We only have limited time to be able to figure it. I'm
Right.
not putting that on any side. I'm just trying to make sure we're doing as much as we can while we're here.
Well, normally, other defense attorneys do it via Zoom when it comes to those experts.
I understand that.
I would have to inquire with Ms. Bossler if she's available to go to the jail and be
Well, what we talked about was setting it up here in the courthouse.
in the courthouse.
And I'm sure I could, get court administration or IT to set up potentially a Zoom where someone could appear by Zoom. Would you have an issue with that, Mr. McDonald, if the
I have an
FDLE
issue with
analyst showed up on Zoom?
If it saves on and doesn't delay the deposition, sure.
I'm just asking the question, sure. Okay, so we can potentially do her by Zoom.
Are you ready to continue?
Yes, go ahead, sir.
All right. Officer Harold J. DeWitt.
Okay.
Harald J. DeWitt, D-E-W-I-T.
Just one T?
Yes, sir.
Okay.
In Shalimar, at Sheriff's Office.
So is that the sheriff's? Okay. All right, who else?
Michael J. Reich.
Are all these people listed on the?
Yes, sir, they are.
Okay, so y'all don't need you to spell them if they're on the discovery exhibit. I can just look at them.
Okay.
All right,
Okay.
so Michael
J. Reich.
Wright?
Reich.
Reich. Okay, who else?
Brandon M. Walters.
Walters, okay.
Yes, sir. And Taylor L. Woodard.
Woodard.
Mhm.
All right, and these are all for the 1950 case?
Yes, sir, that's it, and that's it.
Okay. Anything else?
No, sir.
So what I'll do is we'll start working on that today, just, because obviously we got to get a location
Okay.
organized, and then we'll make sure that subpoenas go out for that, for his benefit, and then hopefully everything will work out.
Your Honor, one question I do have is how much time is reserving for each witness?
How much time do you need for each witness?
15, 20 minutes.
Okay. All right, so that's 1, 2, 3, 4, 5, 6, 7. So about 2
2 hours,
hours.
20 minutes.
About 2 hours.
If the court, how do we go, Your Honor, about scheduling them, the time? Does the court want me to give the dates right now?
I'll have someone reach out to your office, Ms. Leone, just so you understand, Mr. McDonald, since my office is going to take a little bit of a lead in trying to schedule these for you since you can't do it.
Yes.
So my office, not me, my office will reach out to Ms. Leone's office. I just want to make sure you understand that we won't be talking about it, the case or anything else, but they'll coordinate dates at the courthouse with her office, and then we'll get everything set. And then obviously we'll have you transported for that purpose.
Yes, sir.
All right.
So,
But I can't tell you until they coordinate, when these dates might be.
yes, sir.
All right, anything else you want to
Yes.
address today?
Yeah, I know that we talked last Tuesday that, if I had issues, then you advised me that I should bring those issues today with me.
Well, I want to know what the issues are, and then we'll figure out if we have time to do those today. This is a docket day. They're for cases that are being set for trial or pleading out today.
Okay, well, then we'll move forward with the 24 CF 2917 case and those Category A witnesses.
Are you for depositions?
Yes.
Okay, that's what I asked earlier, if there are any other depositions you wanted to do.
But I just wanted to state for the record that there was a separation in the witnesses.
What's this case number, Mr. McDonald?
2917.
2917?
Yes, ma'am.
Okay, go ahead.
$29.17, okay. What do you got?
All right, the first one would be Anthony Ray Krieger of Crestview, Florida, Lark Lane, 5258 Lark
If
Lane.
it's in the discovery exhibit, I don't need you to
Okay.
give it all to me, just give me the names. That's the non-law enforcement witness?
Yes, non-law enforcement.
Okay.
Richard Lewis Goff.
Okay.
And the third one is Wesley Blake Herring.
What was the last name?
Herring?
Can you spell that one for me?
Yes, it's Hearings.
Anyone else?
Yes, sir. Jessica Axelson. Would you like me to spell the last name?
Sure.
Okay, it's Axelson.
Okay. Anyone else?
Yes, sir. Benjamin Browning.
Ms. Leone, if you could obviously take a look at your discovery exhibits to make sure they're on there.
Yeah,
I'm not
yes,
sure if you
sir.
can do that in real time right now. I just want to make sure they're all there.
All right. And Tyler Culbertson. Would you like me to spell the last name?
No, I understand.
Okay.
That's law enforcement, right?
Yes,
Yes.
Okay. What agency is that?
Crestview
Crestview.
PD.
What else, Mr. McDonald?
Rebecca Lynn Feller.
It's a civilian.
Anyone else?
Joshua D. Green.
All right.
Law enforcement.
Russell W. Humbert.
Crestview PD. Former. He's not with Crestview PD anymore.
Robert S. Robinson, Okaloosa County Sheriff's Office.
All right. Mr. McDonald, keep going. This is why I asked for you to write them all down to give us a list, and so we don't have to
I
spend 10 minutes
apologize, Your
going
Honor.
over each name.
I apologize.
All right. The next time I ask you to do that, I would expect you to do it so we can save all this time. Please.
Yes, sir.
Please
From now
give
on,
me the
I
next
will.
person.
Logan Schaefer.
Law enforcement.
Okay. Next.
Stephanie Shea.
How do you spell that, Mr. McDonald?
It's S-H-E-A. She's North Okaloosa Medical.
Okay.
And Jonathan Sprague.
Law enforcement.
I'm assuming that Discovery exhibits have their addresses and things.
Yeah, yes, they should.
They do. And Michael Tingle.
Next.
And one more. Mark Lynn Shade.
Shade?
Yes. S-H-A, S-C-H-A-D-E. I'm sorry.
Is that everybody?
That's it.
Okay. Anything else?
Yes, Your Honor. I had requested from the clerk's office, Your Honor, to be real quick. I know that y'all busy.
That we're busy, it's just I need to know what the things are to see if
All right,
if
well,
we've got
I have
time to
set
do it.
two motions for bond hearing in CL 2917 and the 25 CF 713 case, the new case. But I also requested from the state discovery in 25 CF 713 on or about the 4th of June. I have not received discovery.
713?
Yes, not received discovery. So I can't give you a list of those names.
Have you received that, Miss Leon?
I can check, Your Honor, I'm not sure. If he filed it, maybe we didn't, but I'll check.
And real quick.
What I see on June 4th is a motion to compel discovery.
Well, I have the memorandum with me from the clerk's office. It's either
Well,
the third or
Sir,
fifth.
I'm looking at what you filed.
I understand that, Your Honor.
Okay, did you ever do a notice of discovery?
Yes, I did.
Notice to participate?
Yes.
What day was that filed?
One moment, please.
Sir, I see that you did file at some point, and it looks like June 11th, you filed a notice of hearing, and you just put June, and then it's blank at 9:30.
My file does not show a demand for discovery, but now I'm checking another place.
Motion to compel discovery was received on June 4th.
Sir, again, a motion to compel discovery is what you file when you've asked for discovery
Yes.
through a, hold on, Mr. McDonald, if you could stop shuffling through the papers. You never filed a demand for discovery. So your motion to compel is telling the state that they didn't do something and they need to do it, but you haven't asked for it. That's why I asked, have you filed a demand for discovery or a notice to participate in discovery? That hasn't been done.
Okay, Your Honor.
Well, the rules are the rules. I'm
Yes,
going to
sir.
hold you to them just like I would any lawyer.
Okay.
So if you want to file that, you can pursue discovery that way.
Well, I'm sure that I did, because I do remember doing another one to amend it.
Well, is it possibly filed in a different case because that's happened before in your cases, Mr.
Only
McDonald?
once, Your Honor. I did not do that. I'm not in the habit of doing that.
I understand. I'm just trying to maybe help find where you think you filed something. Trust me, we get filings from lawyers all the time with the wrong case number or a wrong name on them. It happens.
I have made a few mistakes, but I try to check myself before I do that.
And Mr. McDonald, my only reason to bring that up is to make sure we can get it done for you, not to try to embarrass you or anything like that. Like I said, it happens with lawyers all the time.
That's fine.
All right. So if you want to file your notice for discovery in that case, they'll provide you with the discovery. Otherwise, we'll coordinate to get those depositions set in the other cases.
Well, if it's all right with the court, may I orally pronounce it and then set the,
No, it has to be filed and
Okay.
served on them.
okay?
I mean, I'm sure you've read 3.220. You cited it in your
Yes,
motion to compel.
every day.
Well, then you just got to make sure that you're doing things as required by the rules.
Yes.
There was one more issue. I asked last time for him to provide me with a flash drive so that I can put the video discovery on it. He said he was going to inquire with his family members. So I would like to know if you have that.
I was advised that that occurred. Did that occur?
It didn't occur.
Did it occur? So she has it here today.
Okay.
Okay. Well, if you could provide that to maybe court security, could grab that and give it to Ms.
Yeah, and I would
Leone.
like to verify that it's big enough for all the.
And then you said you would ask for a bond hearing, Mr. McDonald?
Yes.
And what cases was that on? I think you only gave me two different case numbers.
Yeah, there was the 24 CF 1950. I mean, not 1950, excuse me, Your Honor, I'm sorry. 25 CF 713 and,
2917?
yes, that one.
Okay.
I'm sorry.
And do you have a bond set in the 1950 case?
Yes, I filed a motion to reinstate that.
So do you want to address that at the same time?
Yes, sir.
Okay. I'm not going to go looking for it right now,
Okay,
but you
that's
filed it.
Yes.
Okay.
Your Honor,
Hold on just a second. I'm trying to find you a date, Mr. McDonald. My next miscellaneous date is July 31st.
okay.
Any issue with that, Ms. Leone?
Can we do August 7th, please? 'Cause
But what about the 10th? What about next week? I
That's
might be able
fine.
to squeeze in. That's what I'm trying to look up right now.
the 10th is Thursday, Your Honor?
Yes, next Thursday.
That's fine.
So we've got the felony plea date, and we've got a few other matters after that.
That would be fine, yes.
So let's go ahead and set it for 2 o'clock.
Thank you, Mr.
On your motions to set bond in 713 and 2917, and your motion to reinstate bond in 1950. Anything else, Mr. McDonald?
I wanted to say that I had gave you some incorrect information about using the flash drives at the jail. So they're going to have to rehouse me in another section in order to use the computer.
Okay, well, I don't have any control
All
over
right,
how
I just
the,
wanted to let you know I gave you some wrong information.
well, I appreciate that. That's why I asked, because I don't know how those things work from a practical standpoint in the jail, but, all right.
All right, thank you.
All right, we'll see. We're going to put you on, like I said, for that July 10th date at 2 o'clock. And then for your next pretrial, I'm going to put you for August 27th.
All right, thank you.
And then we've got, we'll see what we can do on the depositions, getting those set. Obviously, it depends on everybody's calendars. Ms. Leone's, the court, to be able to find a date and a place for you.
Your
All right.
Honor, if I may, would it be possible instead to even put it for this Thursday, the 3rd? I mean, whenever, the 3rd, right?
You want to do your bond hearing this Thursday?
We can.
Okay. Can we change that to the 3rd?
Sorry about that, Your Honor.
No, it's fine. 2 p.m. still. Well, no, let's put it at 1 because I don't think we have enough to get us to 2
Yes.
potentially. I just don't want to be waiting around and
So-
they'll transport you and
All right.
probably wouldn't matter anyway because I have to transport them. I just want to make sure they transport him on time. He's going to come at 12 probably with the pretrial detention people. All right, thank you, Mr.
All right,
McDonald.
thank you. Thank you, Ms. Leon.
I'll do what I can about getting the depositions figured out between now and Thursday, but I don't want to give any promises on that, Mr. McDonald. All right. Ms. Dudley?
First one I have is Adam Phillips in 25 CF 290, 25 CF 292. This is one we were going to continue the court left set today based on the order revoking bond for not reporting a pretrial. Your Honor had mentioned that we can get that resolved. He didn't have to be here today. However, the state objects to the bond being reinstated. Pretrial actually is okay with it. They have sent an email to that about that. They've stated that, unfortunately, it's not uncommon that individuals don't report after the first court date because they believe that they don't have to. I have explained to Mr. Phillips that is not the case. That was his impression as well. I've dealt with this with other clients as well, that they believe that after that pretrial, reporting their pretrial is up to the first court date. Well, obviously, we all know that's not the case. Pretrial is okay with him getting back on pretrial supervision because he was reporting until that court date. They stated they would just ask for an updated phone number and address and an alternative number if he is back released, but they are okay with him getting back on pretrial release.
Sorry, I'm a little confused because I just saw an amended pretrial detention order for him, and then
And it's not his.
It's not his
his
case.
I had noticed that too. I was
It
like,
took
this
me a
ain't him.
second to figure out why he had a pretrial detention order
Yes,
from
sir.
last week.
Yes, sir. It's wrong, filed in the wrong case. That caught my attention too, and I was confused at first.
And I'm not sure why, because the case numbers aren't anywhere close to each other. All right, what's the state's position on the?
The state is objecting to reinstatement of the bond. So the motion, she just filed it this morning. I wasn't ready to.
I haven't seen it, so.
Right.
I did inform the state of pretrial saying that they had no objection. I did inform the state that pretrial stated that this is not uncommon, that people do believe that.
Do you have anything from pretrial?
I have the email, Your Honor.
And you've seen it, Ms. Leone?
I have not seen it, Your Honor.
And when was the motion filed?
This
I filed
morning.
This morning, Your Honor, but you told him to be here today.
I understand, but
You don't have to be here today. I understand that. You told him to be here today because the order. I got in contact with pretrial last week, and then Thursday again, trying to figure out some information that the state had provided. So I'm at approach. That the state had provided as well.
Ms. Leone, have you seen the email from pretrial?
Your Honor, may we approach, please?
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes.
So let's set it for this Thursday at 1 o'clock for regarding the revocation of bond. Just so the record's clear, y'all have any issue with me putting this into the record now? Is it?
No, sir.
An email from pretrial explaining that his compliance and concerns with court dates and things that are mentioned in here, but So, Mr. Phillips, we're going to have a hearing on July 3rd at 1 o'clock.
Yes, sir.
And at that time, everyone's going to put on what evidence they want as to whether or not you're going to, basically which door you're going to leave through that day.
Yes,
If I found that you've knowingly and willfully violated your pretrial release conditions, you're going to be placed in custody.
Yes, sir.
If I find that it was at worst incidental or confusion that caused the problem, then I may release you on that day.
Yes, sir.
Because you came to court today as I requested, I'm going to allow you to remain out of custody until that hearing on July 3rd.
Yes, sir.
However, if there's any other concerns about violations or you don't report to pretrial services as you were required since first appearance, and that continues until there's a further order that says you don't.
Yes, sir.
So I'm not sure how that happens, but I just want to make sure it's clear that you're to continue reporting to them, and the email that I just read says you need to update your information. So I'd like to find out on Thursday that you updated your information on today's date.
Yes,
They
sir.
have an office in this building, right?
Yes, sir.
Do you normally report in person to them?
No, sir.
Okay. I would see if you can just walk them down to the office,
I will.
Ms. Dudley.
I'll have
and-
him wait for me, Your Honor, one more case.
Your Honor, for the record, the state objects to the defendant not being taken into custody, given the order that this court has signed, when I know everybody else will be taken into custody pending the hearing.
I understand that, but the difference is they've provided information from the people who were supervising him that's different from what those same people gave me previously, and that was the basis of the bond revocation.
Right, Your Honor, with the difference that the affidavit was sworn, this is just an email. So the court agreed
All
to...
right, I'm going to pass the case. I'm going to call Ms. Tiffany from Pretrial Services. We'll get her down here this afternoon, and we'll set it for this afternoon. I'm just not going to go back and forth on these cases about these issues. When people are filing things the morning of or talk about how they're going to file things, we're not playing fast and loose with whether or not someone goes into a jail because there may be some confusion about paperwork. So we'll pass the case until later today. I'll have her come over here if she's available, or someone from pretrial who can explain it to us on the record with their hand risen to swear.
May I know the time, Your Honor?
When we get back to it, I'm just going to pass it for now.
Yes, sir.
Yes.
I'm just trying to see if the victim would be available to participate as well. That's why I'm
If she
asking.
becomes available, then we'll have it when she's available.
Thank you.
Yeah, I try to be as accommodating for everyone, but we can't just pass cases, because we have competing constitutional rights to things. Notice, can be provided, but that doesn't mean we have to just keep continuing things because someone can't be here. So let's see what can be done today, and we'll address it.
Yes, sir.
The court is allowed to change its decisions based on new information from the people who had initially provided it. Thank you.
Your Honor, next I have is Jeffrey Todd Wagner, 24 CF 122, 24 CF 121, and 20 CF 380. Your Honor, can me and the state approach real quick?
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for
Mr.
Northwest Florida
Wagner's
for over
cases,
34 years.
we're leaving
Come
that
in and let
currently
us take
set
care
for
of you.
trial. That was trial, it was on the 21 and 22 cases?
Just the 22 case, Your Honor.
Just the 22.
Your Honor, my understanding the state's going to go forward on count 3 of the 22 case.
That is correct. Counts 1 and 2 we will not be moving forward on.
So we'll leave that set, but I'll certainly, if y'all can still resolve it, I'll consider that on next Friday, the 10th, no, 11th.
The 11th, right, Your Honor?
The 11th.
Yes, sir.
And for scheduling purposes, if it does go to trial, Your Honor, the state doesn't anticipate it taking more than a day. I think it could be a pick and go.
I think that's appropriate.
All right, I appreciate that, Mr. Sheik. Ms. Dudley, we'll see you back on July 11th
Yes, sir.
for jury review.
Yes, sir.
Thank you, sir. All right, who do we have next?
I've got a few.
I want to call out of custody people to get them on their way.
Yes, sir.
Okay.
Marcus Barkley.
Barkley.
Where's the lady?
Judge, this was set plea or continuance for me to get the defendant in and go over the offer.
I heard last time it was a 3-year DOC offer.
Yes, sir. I was not able to get him in, so it was set plea or continuance. I'm going to ask to continue it.
State.
This was which one, Mr.?
Barkley.
Bill Marcus
That's fine,
Barkley.
Your Honor. I spoke with Mr.
I'm going to call this last continuance, Mr. Barkley. This has to be resolved at the next pretrial. That's going to be on August 25th. And when I say resolved, it's either going to be a plea or set for trial that day, but this case is from January of 24. So I'm not going to consider any more continuances short of something that's out of everyone's control. August 25th, 1 o'clock.
Thank you, Judge. All right, come back in.
Yes, sir.
If you want to, I can talk to you tomorrow at 11:30.
Yes, sir. That'll work.
Okay.
Thank you.
No problem. Anthony Scott Brown. Judge, we had passed this for me to locate a witness, Nancy Kinman. I was able to locate her, and I gave a statement to the state. I think we're probably going to need to set her for depo. She was actually listed by the state, so it was set plea or continuance. I'm going to move to continue it.
What was the name again?
Anthony Scott Brown.
No, the witnesses. No.
Oh, Nancy Kinman. Okay. And Ms. Kinman at least was present earlier today.
All right, so that's just the last deposition that needs to be done?
Yes, sir.
State have any objection?
No objection.
All right, August 25th at 1 o'clock, Mr. Brown, be back on that date. I expect to hear deposition's been set and hopefully accomplished by that date if possible. Case is over a year old as well.
All right, thank you. Do me a favor. Bring it back in and I'll get it from you in a minute.
Yes, sir.
Jerry Clckler. Judge, it was set plea or continuance.
I think that was the issue. He was taken into custody at our last court date. Any objection from the state?
No, Your Honor.
All right, August I'm going to put it on the 25th at 1 o'clock since he's not in custody here, but obviously if he ultimately is transported back here for any reason, then we'll put him on the 27th.
Yes, sir. It's always easier to reset him 2 days in the future than 2 days in the past. George Hastings Davis. Judge, Mr. Davis is approaching. This was set clear continuance. I think we're still waiting on something from the state. I think the case can probably be resolved without depots, but I need to have some idea as to what he's facing other than DOC.
You're saying you know it's going to be a DOC offer, but not.
She announced last time it was going to be a DOC
That's what I
offer,
have.
Judge, but I still don't have a specific offer.
Have y'all conveyed a specific offer, Ms. Basso?
I thought I had done that. It was a 3+7 offer, 3 years DOC followed by 7 years executed probation. I believe designation.
Ma'am, I went back through my emails.
I think we probably just talked about it. I'll shoot it to you in an
Okay.
email so you have it.
Thank you.
All right, so based on that, what do you want to do?
Continue the case, Judge.
Not terribly old, 8:25 at 1 o'clock. For your next pretrial, Mr. Davis, be back on that day. Stay in touch with Mr. Williams so you can talk about that offer.
Thank you.
Yeah. Jacob Gabony. Judge, I was unable to reach Mr. Gabony since docket day, despite a few attempts. I'm going to have to continue the case. Mr. Gabony, can you come in and see me tomorrow at 2 p.m.? Okay. And just so you'll know, that's what the offer is. 3 years probation.
Wasn't Mr. Gabony, he was late to court last time, right?
I don't recall, Judge.
Because I have where I wrote down there was a capias and I crossed it off and withdrew it.
I was.
And now your lawyer is saying he can't get in touch with you.
We talked on the phone.
Okay, so when do you want to set this case?
Judge, I was going to move to continuance since it was set plea or continuance.
All right, any objection from the state?
No objection.
All right, Mr. Gabony, stay in touch with Mr. Williams. You need to talk to him so he can work your case. You also need to make sure you're here on time.
Yes, sir.
So I'm going to put it on August 25th at 1 o'clock for your next court date.
Okay.
Be there early.
Yes, sir.
Thank you.
Joseph Matthew Gayy.
Gayy? Is Mr. Gayy here?
Judge, I think I saw him earlier today, and he asked if I was going to talk with him. I told him that I'd come get my note and step out and speak
He might
with
be
him.
in the hallway. All right, pass him and recall him once he's here. Otherwise,
thank you.
We'll talk about a capias or not, but it sounds like he's just in the hallway.
Cody Hinesley. Judge, Mr. Hinesley's approaching. Judge, the state and I have gone back and forth on an offer. I've spoken briefly with Mr. Hinesley by phone and then again in the hallway today. At this point, it doesn't look like we've got an agreement. This is one where he'd been on conditional release. I was trying to get the case resolved with time served, but the state wants probation on him.
What would you like?
Judge, I'm going to have to ask continuance since it was set plea or continuance and it's not going to be a trial. And Judge, I don't see this ever being a trial.
Are these all from 2022?
Yes, sir. He was determined to be incompetent and has been in competency restoration for quite some time.
All right, state.
No objection, Your Honor. I just would like to inquire with Mr. Williams as to, I thought we had negotiated it, and I said,
We had talked about it I talked about the change, the early termination with him this morning. He doesn't want to take that. I'll talk with him some more. I'll talk with you some more, but I don't know that we're going to be able to resolve it the way that you're wanting to resolve
He
it.
doesn't want to pay the restitution?
He's fine with paying the restitution.
Okay, so if he can pay it before next court date, then maybe we can have a resolution.
That would be great, thank you. Did you understand that? Okay.
All right, so August 25th?
Yes, sir.
1 o'clock. We can get that one resolved at that time.
Yes, sir. And sir, if you can get that restitution paid before then, probably it'll go away.
Okay.
William Jack Hinesley. Judge, I know the state's anxious to get the alibi, notice of alibi filed. I try to talk to the alibi witness before I file those, though, and despite a couple of attempts, I've been unable to reach Mr. Livingston. I'm going to ask Mr. Hinesley to help me with that and ask him to have Mr. Livingston give me a call.
This is a case from 23?
Yes, sir, it is. If the court goes back through, you'll see initially the state we had moved to continue. We took her deposition. Then the state moved to continue it. The state's provided now an expert witness. I'm not really sure what she's going to testify about unless the alleged victim is changing their testimony. I can provide some more detail to the court, but the short version is her testimony at deposition would not establish a rape. We can't do a C4 on it, though, because we're not agreeing to any of the other operative facts.
Looking at demand for notice of alibi was done February 13th of 24.
Yes, sir.
So why are we 16 months later still talking about
I
a
was-
potential alibi witness?
I was not advised of an alibi witness until the court date before this one.
All right, well, I'll certainly consider any objections to it as well, once it's actually done. So you're asking for August?
Yes, sir.
State's objections?
No objection.
All right. I don't expect I'll continue this case again.
I don't want to continue. I want to
But,
open it.
Mr. Hinesley?
Sorry.
Just, this case is 2.5 years old. No, I'm sorry, 1.5 years old. But basic witnesses should have been done well in advance of today.
Yes, sir.
So, last continuance. August 25th at 1 o'clock. Mr. Hines, I didn't mean to stop you from talking. That you're allowed to talk, but I just wanted to make sure I got that out first.
Okay, Your Honor.
Christopher Krivick. Judge, this is Mr. Krivick. The case, I don't believe this one is all that. No, it is. It's from 2024. Anyway, it was set plea or continuance. I've talked with Mr. Krivick. He's not going to accept the state's current offer on it.
Anything else to do before trial next time?
Just have him sit down and watch some videos with me, Judge. I don't know that there's any point in me doing depots on it. The videos are pretty clear.
All right. Any objection from the state?
No, Your Honor, no objection.
Having heard nothing else that needs to be done before the next trial period other than watching videos, that should be pretty easy in a 2-month period. I'm going to go ahead and say last continuance on this case as well.
Thank you, Judge.
And so it'll be over a year old at that point.
Yes, sir.
All right, Mr. Krivick, come back on August 25th at 1 o'clock. Stay in touch with Mr. Williams. Make sure you make an appointment to go watch those videos. And I'll see you back on that court date.
Should I come back?
Excuse me?
Was the appointment you scheduled for the 29th of July?
Anything else, Mr. Williams, as far as people that are here?
Judge, I think that's all the people that I have that are not incarcerated. Is there anybody else here for Jay Williams?
All right, thank you.
Your Honor, may we recall Miss Redden?
Redden? Redden? This is the petition for the expungement.
Yes, Your Honor. The state nor the victim have any objections. The victim declined to be here in court. He said it's been 13 years since this happened, and he does want charges to be expunged off the defendant's record.
Did y'all talk to him?
Yes, Your Honor.
What I'm going to do is I'm going to grant your petition, Ms. Redden.
Thank
I know you did an order. I'm going to have to take a look at it to see if you got it all right. Okay. No offense. I just want to make sure that there's no problems because I don't want it to be a situation where it didn't work properly.
Okay.
So, do is just file it in my folder so I can make sure to take a look at it. Where is it? All right. So it'll get signed for you. I just want to have a chance to look at till probably later today or tomorrow.
Okay, thank you so
All
much.
right, I just want to make sure there's nothing.
Okay.
Trust me, like I said before in other cases, even lawyers get things out of order or something like that. I just have to make sure, and I don't have time to look at it while we're all sitting here. But I'll do it as soon as I can.
Okay, thank you
All right,
so
thank
much.
you, Ms. Redden.
All right.
Safe travels back. All right, Ms. Rivers, are you ready? Do you have any out of custody people? Mr. Russell? Okay. Let's just try to get everybody out of here that we can as far as out of custody people. That'll take a very short recess, and then we'll get to the in custody.
First one, Judge, is going to be Daniel Bell. For the record, case numbers are 24 CF 1340, 24 CF 1355. He was here, Judge, but he left. Daniel Bell.
Daniel Bell.
Let me skip and I'll come back, Judge. Coretta James.
I didn't have Daniel Bell, for you at least.
Page 27 on my docket.
All I have is Michael Bell on page 27.
Oh, I'm sorry. Michael Bell.
Okay.
There we go.
Let's let Mr. Bell, let's hand him, oh, okay.
Sorry, Judge, that's my bad. Michael Bell is present and approaching. Case numbers are 24 CF 1340, 24 CF 1355.
I have to unring that Daniel Bell. Get up Michael Bell.
On Michael Bell's cases, Judge, these are the ones that we had depositions set for June 26th.
Last week. Yeah.
Yes, sir. We had 12 out of 20 show, which was pretty
Not
good.
bad, 60%.
Yes, sir. But there were still some witnesses that we needed to talk to. Some of the officers were at training in Orlando. There were different issues.
Okay.
So we're just asking for a continuance to the August 25th docket.
No objection from the state, Your Honor.
Are y'all going to try to get those reset before then?
Yes, sir.
Okay, because this case is over a year old now.
Yes, sir. We'll get those taken care of.
All right, it's going to be August 25th at 1 o'clock. Be back on that date, Mr. Bell. Stay in touch with Mr. Russell. Okay, we'll see you on that date. Ms. James?
Coretta James, Judge, this is 16 at CF 2265. State recently filed an amended information. I don't know that it's going to show up. I have a copy if the court wants to look at it. They added a charge of failure to appear. We've reached a plea agreement. It's going to be a no contest best interest plea to a misdemeanor. May I approach?
Yes. Y'all have the amended information? Does it say what date? Is that like a filed copy or is it just a copy?
Printed out copy of the notarized one.
Well, they're just that it's been filed.
It has been filed.
Yeah, but it doesn't have a filing number or anything. And y'all can't see
Copy
it.
that I have, Judge.
And well, the only thing that's been amended is a new charge, which is now being null-prossed.
Yes, Your Honor.
Okay, so I think we're safe going forward. All right, Ms. James, can you raise your right hand? Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Redden James, August the 8th, 1983.
All right, Ms. James, you're here in 16 CF 2265, charged with grand theft of a controlled substance, third-degree felony, obtaining drugs by fraud, third-degree felony. Those are both punishable up to 5 years in state prison. It's my understanding since last time we were here, the state's filed an amended information to include a failure to appear charge, which is also a third-degree felony, but that part of this plea agreement is for that to be dismissed.
Yes, sir.
Is that your understanding?
Yes, sir.
All right. I've got a plea and sentencing agreement that calls for you to plead to a lesser included of possession of paraphernalia, first-degree misdemeanor. On count one, it'd be an adjudication of guilt, time served, $270 court costs, $114.45 cost of transportation. Do we know who that's to?
It's going to be OCSO, Judge.
OCSO, okay, to the sheriff's office, $100 PD fee within 90 days of, or it'll go to a judgment against you. And then the obtaining drugs by fraud, that's going to be dismissed, correct, Mr. Sheik?
That's correct, Your Honor.
And you're also, according to this, null processing the alleged failure to appear, or I guess alleged information showing a failure to appear. Okay. You feel comfortable, Mr. Russell, going forward without that information, or we can see it in the court file since it's only adding a charge that's being dismissed?
Yes, sir.
Got it resolved, right? All right. So is this what you want to do, Ms. James?
Yes, sir.
Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir, I did.
Did you understand it?
Yes, sir, I did.
Did you sign it?
Yes, sir, I did.
All right. Are you satisfied with your lawyer's advice and representation?
Yes, sir, I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Do you understand? I'm sorry. Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind,
Yes, sir.
and you're giving up your trial rights that are on page 2 of this document.
Yes, sir.
All right. And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
Do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the lesser included possession of drug paraphernalia, first-degree misdemeanor?
No contest.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty. Time served. $270 court costs. $114.45 cost of transportation to the Okaloosa County Sheriff's Office, and a $100 PD fee. You have 90 days to pay for those. Or there'll be a judgment against you. All right. State have an announcement on counts 2 and amended 3.
We'll no process both of them.
Okay. So counts 2 and 3 will null processed by the state. I don't think I need your fingerprints for paraphernalia charge, Ms. James, so I just need you to know that you have 30 days to appeal the judgment and sentence.
Okay.
All right, thank you.
Thanks.
Next case, Judge, is going to be Diana Patricelli Freeman. For the record, case number is 24 CF 1963. This was passed, Judge Plea continuance. We've worked out an agreement. It's going to be best interest, no contest plea to a lesser included misdemeanor possession of paraphernalia. State's going to null process count 1. May I approach?
Yes, sir. All right, ma'am, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes.
All right, and state your full name and date of birth, please.
Diana Marie Patricelli Freeman, 11295.
All right, Ms. Patricelli Freeman, you're here in 24 CF 1963, where you're currently charged with battery upon a person over 65, third-degree felony, and count 2, possession of controlled substance, third-degree felony. Both of those are punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
Okay, and I've received a plea and sentencing agreement between you and the state that calls for that count 1 to be dismissed by the state, and count 2, lesser included offense of possession of drug paraphernalia, first-degree misdemeanor, adjudication of guilt, time served, $270 court cost, $100 PD fee. Pay that within 90 days, or it'll go to judgment. Is that what you want to do today?
Yes, sir.
Did you go over this form with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressure, or threatened you to enter this plea?
No, sir.
Has anyone promised anything in order to get you to enter this plea?
No, sir.
By entering a plea, do you understand there won't be a trial of any kind?
Correct.
And you understand there won't be, you're giving up your trial rights that are listed on page 2 of the agreement you signed?
Yes.
And do you understand you're waiving any potential defenses that you may have?
Correct.
You understand that if you're not a U.S. citizen, you could be deported because of this?
Yes.
All right. And what is your plea to the lesser included possession of paraphernalia?
No contest.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty of the first-degree misdemeanor, time served, $270 court cost, $100 PD fee to be paid within 90 days, or it'll go to judgment. State have an announcement on count 1.
State dismisses count 1 in exchange for a plea to count 2.
All right, thank you. 30 days to appeal the judgment and sentence. Make sure you get that those fees taken care of.
Thank you.
All right, thank you, ma'am.
Next judge is going to be Dakota Perry. Case number is 24 CF 936. Mr. Perry is present and approaching. Judge, we've worked out on Mr. Perry's case a plea to counts 1 and 3. This is going to be a best interest plea. State's going to drop count 2, and he's going to do pretrial intervention on counts 1 and 3. May I approach with the paperwork?
Sure. Thank you. Sir, can you raise your right hand? Do you swear or affirm the testimony I'm about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth, please?
Dakota Perry, October 27, 2005.
All right, and Mr. Perry, did you say 2005? Sorry, it's not you, it's me. I feel much older right now than I did 5 minutes ago. All right, Mr. Perry, you're here in 24 CF 936. You're charged with 2 counts of criminal mischief, third-degree felonies, as well as leaving the scene of an accident or with property damage, second-degree misdemeanor. I've been handed a plea and sentencing agreement that calls for the second criminal mischief, count 2, to be dismissed. Count 1 and 3, you'll be doing a pretrial intervention agreement. So you're entering a plea to that, but if you do everything you're supposed to through that agreement, the case, your plea can be withdrawn and the case dismissed. Do you understand that? But if you fail to do to complete the pretrial intervention, that you would come back and be sentenced by the court. Yes?
Yes, sir.
I just need to hear you out loud so the microphone picks you up. All right, so that means if you were to fail the pretrial intervention because you have a third-degree felony and a second-degree misdemeanor, if you come back for sentencing, the court could give you as much as 5 years and 60 days in county jail. Do you understand that?
Yes, sir.
All right. So it gives you good incentive not to do that. Right?
Yes, sir.
Okay. All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you to do this?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which are listed on page 2 of the agreement you signed?
Yes, sir.
And do you understand that if you're not a U.S. citizen, you can be deported because of this?
Yes, sir.
All right. And what is your plea to the criminal mischief, third-degree felony, as well as the leaving the scene of an accident with property damage, second-degree misdemeanor?
No contest.
All right. I'm going to accept your no contest plea is freely, voluntarily, knowingly given. State have an announcement on count 2.
It will null pros count 2, Your Honor.
All right. So you're due the pretrial intervention agreement. Has that been given to probation?
It's in the.
Oh, it's in the packet?
Papers, Judge.
I thought it was just the guidelines with it. Okay. All right, so that involves, looks like restitution, at least $75 a month. You understand that, Mr. Perry?
Yes, sir.
Okay. And you went through this agreement with your lawyer as well?
Yes, sir.
And you signed it and understood it?
Yes, sir.
Okay. All right, this is a Well, we'll talk about guideline sentence, I guess, if we ever get to that point. Hopefully we don't, Mr. Perry, because you finished this up and the case ultimately is resolved that way. So just get in touch with probation. They'll explain, do y'all need this one back?
Oh, yes, that's the original, Judge.
Okay. Status date, how long is that agreement? I'm sorry.
Years, Judge.
Years. Well, I don't really have a date to check on that. All right, just, I guess, June 30th, 2027. Oh, I'm sorry, you're saying just, sorry, I've got back into juvenile mode. So August 25th for a status date, just to make sure your paperwork gets through. There's a little bit of a log jam right now with some software changes. I'm sorry, I misunderstood you. I just was thinking about juvenile, where we have to give them that date. It's usually only 6 months away.
And Judge, I have one more case that didn't make it on the docket. It didn't make it on the docket at pretrial conference either, but Christine Hamilton, 24 CF 1263. She's present and approaching. Judge, it was passed to today for plea or continuance. We have reached an agreement in Ms. Hamilton's case. She's pleading to her charge with the understanding she's been given a pretrial intervention agreement, which I'm going to provide to the court, but I have a plea agreement score sheet and the plea agreement, pretrial intervention agreement.
Yes. Thank you, sir. All right, Ms. Hamilton, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Christine Hamilton, 11/1975.
Can you just get a little closer to that microphone?
Christine Hamilton, 11/1975.
I can mostly hear you, but I just want to make sure the record's picking you up. All right, Ms. Hamilton, you're here in 24 CF 1263, charged with a failure to redeliver leased personal property, a third-degree felony punished by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that would have you enter a no contest plea, do a pretrial intervention agreement, and then if you complete that, which looks like it mainly includes restitution of $1,249.01, that your plea can be withdrawn and the case dismissed if you do that. Is that what you want to do?
Yes, sir.
All right, do you understand that if you don't complete your pretrial intervention program, you come back in front of the court, which can sentence you up to 5 years in state prison? Do you understand
sir.
that? So you've got a lot of incentive to make sure you get that done,
Yes,
right?
sir.
All right, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's representation and advice?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this
No,
plea?
sir.
Has anyone promised you anything in return for the plea?
No, sir.
I'm trying to find that. I'm writing my motion now.
Background noise. And do you understand if you enter this plea, there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which are listed on page 2 of that agreement that you signed?
Yes, sir.
And do you also understand that you're waiving any potential defenses that you may have?
Yes, sir.
You understand if you're not a U.S. citizen, this plea could ultimately lead to your deportation?
Yes, sir.
All right, what is your plea to the failure to redeliver leased personal property?
No contest.
All right, I'm accept your no contest plea as freely, voluntarily, knowingly given. Have you do the pretrial intervention agreement, which I have here, and it looks like it's the original, so I'm going to give it back to you, Mr. Russell, so you can give it to probation, but I've reviewed it. And then meet with probation so they can explain those things and tell you how to report to them. Then you'll have 30 days to appeal. See, status on August 25th at 1 o'clock. You won't have to be here unless the paperwork hasn't gone through, so just make sure you do what you need to do.
Thank you.
And same thing for Mr. Perry, Judge. Doesn't have to be here on the 25th.
Doesn't have to be here, but unless the paperwork hasn't gone through, but we'd like to know about it.
Yes, sir.
All right,
That's all
apparently
my
I have somebody on Zoom. Is that the last one of yours, Mr.
That's all
Russell?
mine, Judge.
Apparently we have someone on Zoom. Let me see if I can handle this to get this person off and the Zoom and.
You are in the meeting now.
All right. As far as on Zoom, Mr. Tyree, what are you here for?
Hello, I'm here for the land at Winnington.
Okay.
Sentencing.
I think that's for this afternoon.
Yes, Your Honor, maybe the time difference, the time change. Here is Central Time, sir, and it's almost 12:30, so we need another hour.
I understand. Yes, ma'am. No problem. I'll sign off.
All right. Thank you, Mr.
Thank you.
Tyree. All right. And who do I have on the Motorola? Ma'am, on the Motorola Moto G Stylus 5G 2023, can you announce your name, please?
Michelle Bigum.
Okay.
Your Honor, it appears that Ms. Bigum is represented. Ms. Grant had just dropped off, and she's logging back in right now.
Okay, that's who I was told was on there. That's why I got the Zoom on. All right, while we wait, why don't we bring up Phillips? All right, Ms. Bigum will be with you in just a moment.
Okay, thank you.
Oh, you're approaching. All right, so Mr. Phillips, we're going to bring you back like we talked about on July 3rd. That's this Thursday at 1 o'clock. Make sure you stay in touch with Ms. Dudley, stay in touch with pretrial services. If you've got a report between now and then, we'll see you back on that date. And then we'll have our final hearing as to the issues with your bond. But I'm not going to have you taken into custody at this time based on the new information that was provided by pretrial services.
Yeah, I think for the record, are you calling the KPS today on Thursday if you decide he will go to jail that day?
Yes, recall any KPS on them right now, but it'll be readdressed that day. And
Yes,
I always try to make sure I say these things so you understand them, but at the same time, Mr. Phillips, I don't want to make it sound threatening.
Yes,
Just
sir.
so you understand, if I find there's an issue with your reporting to pretrial supervision on that day, I may put you back in custody.
Yes, sir.
So be prepared for that.
Yes, sir.
All right, thank you, Mr. Phillips.
Yeah, that's all I have. Thank you.
All right, thank you, Ms. Dudley. All right, let me bring in Ms. Grant. The order revoking bond. All right, Ms. Grant, are you there? Ms. Grant? Attorney Alyssa Grant? Ms. Grant, I believe we're here on the Bigum case on your motion. Ms. Grant, if you could respond, please. Ms. Bigum, are you hearing me or no?
I do hear you, yes, sir.
Okay. Ms. Grant, can you hear me? Well,
Can you hear me?
I couldn't until just now.
Okay, sorry, I had to click something on my settings.
That's how Zoom works, yeah. Ms. Grant, we're here on your motion. This is 25 CF 1137 with Ms. Bigum, who's also present via Zoom. We're here for your motion. Go ahead.
Yes, Your Honor. This is a motion to withdraw as counsel for this client. She has indicated that she would no longer like representation from the ticket clinic.
Okay. Ms. Bigum, is that accurate?
Yes, that's correct.
Okay, I'll go ahead and sign the order allowing Ms. Grant to withdraw. What is your intention going forward, Ms. Bigum? Are you going to try and hire other counsel?
I was hoping I qualified for a public defender. I just can't afford
Okay.
to do anything else. So I don't.
All right. Well, Ms. Grant, you just got on this case a couple of weeks ago, right?
That is correct, Your Honor. And the motion to withdraw was filed the day after we got on the case.
Well, I would say don't make that a habit in my court. All right.
Absolutely not, Your Honor.
All right, thank you. You're free to go. Ms. Bigum, if you could just file with the clerk an application for agency and appointment of a public defender, you have to do that through the clerk's office, and then I'll entertain giving you a public defender at that time. You're currently set for a pretrial conference on August 25th at 9 o'clock.
Your Honor,
Okay.
does the state have an offer? Okay, never mind.
Okay,
Just
we'll
ask
see you
her
back on that
details.
date, Ms. Bigum. Make sure you fill out that paperwork and send it in advance so I can appoint you a lawyer before then if possible.
Yes, sir. Thank you. I appreciate it.
All right. Thank you.
Thank you, Your Honor.
All right. All right. All right, everyone, we've been going for 3.5 hours. We're going to take about a 15-minute recess, and then we'll start taking all the other cases from there. Mr. Williams, you got Mr. Pitkiss here, right? Did y'all talk? Pitkiss? Oh, that's Mr. Okay, I just wanted to make sure we had tried to handle everybody who was out of custody, but,
I have, these are all out of custody, Your Honor.
all right, we're going to take a 15-minute break, and then we'll come back at 12:45.